Uh, may I, may I, may I mention one matter, my lord? Yes, my lord. The amendment order was passed, my lord. The amendment was not carried out. This is the last order, my lord. This is the last order. I am
not yet carried
not.
out.
I only. Yes, yes.
Lordship, I am mentioning with regard to a matter, my lord, where Lordship was pleased to restore the suit. My lord, there has been a change of advocates, my lord. When the other side has informed us, the defendant has informed us that there has been a death in the family of the defendant, so we have taken out an application for substitution. Now, my lord, what had happened, when I am trying to file the application before the department, they are saying, my lord, the erstwhile advocate has not filed their vocalatnam. But it is, it cannot be, my lord. He has to file it. Otherwise, he cannot proceed with the matter. Yeah, fortunately, Mr. Basu is here. He was the erstwhile advocate.
You will see, go and ascertain the position.
No, my lord.
Thereafter, you mention.
No, I have ascertained. I have physically gone there, my lord. They are seeking, my lord, a leave to file the wakalatnama, my lord.
Your Lordship, this is not a chamber matter. Your Lordship,
No, mention it after the chamber matters are over. Call the list.
my lord, this is my application, my lord, for appointment of a trustee.
What is the defect? Yes.
This has been taken out pursuant to a scheme framed by this honorable court.
We go through this. Let the defect be removed. Let the defect be removed. No, let the defect be removed thereafter. Go to the department, then again. Go, okay, go to the record.
My lord keeps it, my lord, on Monday.
And go back to the department after the defect is removed. You will again come.
Lord, I appear, Lord, for one of the parties. This is a partition suit of 1940. Lord, I will address on the defect also, my lord.
Okay, remove the defect.
My lord, your lordship, so far as removal of defects is concerned, my lord, kindly takes the petition once. Just once. Kindly takes the petition. Yes, the defect, I'll just answer the defect. Kindly takes the petition once. The defect relates to not striking of the name of the defendant number 5A. Kindly comes to page 32. That is the amended plaint. 32, my lord. Kindly sees, my lord, the parties have been added. The legal is at page 33 is the answer to the defect. At the last, my lord, Zora Suleiman Duple. We have striked out in the amended plaint. But in the prayer, my lord, it has not been sought for, but my lord, that's a technicality.
Anyway, seek it in the prayer, okay?
Lord, then, Lord, I'll have to file a fresh application in that.
Let the defect be removed. Or you want to leave, you guys
No.
grant you that leave.
Your lordship kindly grants me leave, my lord, to incorporate the prayer, my lord, by writing it through.
Leave is granted to remove the defect.
Through hand, my lord, through pen, my lord. My lord, kindly mentions, otherwise they'll not allow.
And granted to remove the defect in court.
In court.
And what the defect application be served upon, what are the defects they are removing?
We will make the changes and in front of my learned friend. Ekhane 5 here jayega, 5 CO2 ki. Number 6. Grateful, my lord.
To remove the defect in court.
And your lordship is keeping the matter on returnable. It's a very formal application, lord.
But Tuesday it will appear.
Grateful, lord.
Huh? Item number 6, my lord, I am for the applicant. And last occasion, my lord, directed on 14th August to special officer to go and inquire that whether any legal error is present of Mrs. Sudhumato.
Yes.
Fix for that.
Let the copy be circulated.
From the report, page 2, my lord, last paragraph.
You don't have anything to say?
My lord, no,
Yes.
because
Learned advocate for the petitioner executor is
executor.
present. Learned special officer is present in court and has filed the report, perused the report and considered. It is stated by the special officer that he has visited the residence of the deceased caveatrix at Calcutta and then at Akrapur, Kichancha district, Ambedkar Nagar, Uttar Pradesh, as well as, yes, any other place? These are the two places. And for making inquiry and being satisfied,
Panchayat office also.
satisfied from the office of the Panchayat that there are no legal heirs of the caveatrix Srimati Sudama Devi. Thus, would be kept with the record. Let this matter appear on
The report, the probate is with the original side register. My lord, since it was treated as testamentary, kindly direct the register original
this
side.
matter appear on 16/9/2025 for consideration, further consideration of the application and necessary orders.
16, I will not be here.
Any further
lord,
role of the special officer?
actually,
is
my
not
lord,
there.
my lord, special officer is not there.
Okay, okay.
Since, yeah,
I'm keeping it on 16
if my lord kindly directs the register original side to
to let it appear under the heading chamber application is adjourned. Learned special of to appear under the heading chamber application adjourned. Learned special officer stands discharged. Let a further remuneration of 600 gems be paid to the learned special officer.
that day, my lord, it will be disposed of.
Anyway, cost you have paid.
Cost remuneration you have already paid. Further
No, that was initial, but
Initial.
this is a
That will we also pay.
exclusive visiting Uttar Pradesh.
Yes.
So let
We
a
will
further
also pay. No,
remuneration
no,
of
no,
600
no
gems be
difficulty.
paid.
My lord,
At your office.
deeply obliged. 16th of September,
16th of September.
deeply,
The original records of the probate we put
Probate.
up.
deeply obliged.
My lord, this is my application for the revocation of the probate, my lord. And my lord,
What is the defect?
my lord, certain numerological defect, my lord, liberty may be given.
In court of the address.
Yes.
Okay, let the defect be removed
My lord, in the court, my lord.
served, my lord.
and a fresh copy be served.
My lord, defect can be removed in the court, my lord, liberty may be.
Defect be removed in court and a fresh copy be served. Let this matter appear on 16/9/2025.
Under the, my lord, same heading, my lord.
Yes, yes.
Millet, we find from the Millet case status, Millet, some additional documents have also been filed. Well, if he has filed anything other than the application, let that be served on us also.
No, no, this is the only
Because on
application.
20,
The
Millet,
application which you
Millet, on
remove.
27th August, Millet, additional documents have been filed from the case status. It's available. My officer can check.
I have to take up only this application.
Yes.
If he has Millet filed anything, this is connected to this PL only.
No,
Let
what
that be
else-
served.
No, no, what else is it?
Because
filed?
let he has filed two things. One on 27th August, that's available from the case status. Mileage officer can check, and another on 8th of
In the
September.
event additional
Yes.
documents
If
are
anything
filed,
has been filed, let that be
let the
served.
same be served upon the learned advocate for the opposite
Yes,
party.
obliged.
Learned advocate for the petitioner is present. Defect is pointed out by the department. Let the defect be removed and go through the defect. Thereafter, matter report up. Yes.
Decree holding. Lordship, I'm told that there is some defects in the application. Lordship,
The defect be removed.
yes, permit us to
What is
cure
the
the.
defect? Yes, let the defect be removed and thereafter the matter be put up.
Lordship, may I have
The
a,
removal of the defect, let them serve us a
After
copy.
no, after the defect is removed, let the matter be put up.
and we'll serve a copy.
And
We'll serve a
serve
copy.
us a-
It will be served.
Yes.
Normal copy serve होगा. Copy serve है. अच्छा. ठीक है sir. আমাকেও তো copy দেয়. 13, 14 both. 14 I am not appearing. In 14 I do not know who's appearing.
10.
I don't know, somebody is there.
Then for the petitioner,
Yes, Lordship.
there is the defect. Okay. Let the defect be removed and the matter be put up.
And after service,
Service.
The
Lordship,
will be served upon the
You are appearing for
decree
the
holder.
decree holder.
opposite party. This petition, you are the opposite.
No, she was asking me, I was telling her.
She is the applicant, means you are the opposite.
Yes, yes.
Yes, Lordship. Lordship, it has already been served with the cure defect. I'll I'll serve it again. Obliged, Lordship.
At number 11.
Yeah, and for the respondent, your Lordship, judgment data.
The holder.
No, and the judgment data.
This is GA2.
GA1 and GA1 was filed by me, stating that the decree has been satisfied to that effect. GA2 was filed by them. Meantime, your Lordship, as it had fallen from your Lordship, we were trying
The
to
talks for
talks
settlement
for
also.
settlement. We had written a letter,
Yes.
but still we have not been able to finalize and sit because the award holder is situated in the decree holder is situated in Germany. So as such, we have not been able to sit.
The learned advocates for the parties are present. As talks of settlement are going on, let this matter appear on 4/11/2025,
Instead of 2 weeks after the vacation as a submission, your Lordship.
month of November.
Your Lordship, second week of November because
Okay, 11/11/2025.
your Lordship. Obliged.
Not today.
At number 13.
13 your Lordship.
Lordship, I'm appearing for the judgment data.
I appear
Lordship,
for the decree holder. Lordship would kindly take Lordship's last order of 26th August 2025. Lordship, my learned friend had preferred an appeal against the decree and also an appeal against the order passed by the executing court. But there is no stay as yet. Lordship had,
This is the decree.
yes, 26th of August 2025. Lordship would kindly take Lordship's order of 26th of August.
27th of August, there is another order.
9th September.
Lordship, we have preferred an appeal and the matter got dismissed for default on 17th of July and on 27th of August.
What was the order you see?
27th of August, I'm handing up the copy of the
No,
appeal court.
26th August.
Yes.
27th August,
7th, my learned friends mentioned and had it,
the matter has been restored.
but there is still no order of stay. Your Lordship's order is quite clear. To bring necessary orders. There is no stay on the execution.
Lordship, the matter has been restored and we're enjoying on its stay.
Was there any earlier
Yes, sir, there,
order of stay passed earlier?
yes, Lordship.
There was an order of stay.
Lordship, there was an earlier order of stay.
Where is that order?
That they would
This
continue.
You have,
to stay.
you have
No, no,
given
what
it
is
on
that
the
order? Earlier
order of stay has been
we are enjoying a stay.
earlier
Thereafter
occasions.
by you, this order it was dismissed.
Earlier, we have submitted that order on the last occasion.
Oh, you have it now.
Hand of course.
No, I can have the
Okay,
soft
let
copy.
this matter stand
Then give
adjourned
it-
till
Next.
16/9/2025. Learned advocate for the judgment in the topics that earlier there was an order of stay passed by the Honorable Appeal Court. Let the said order be produced on the said date fixed.
Lordship, I will produce it.
My lord, in item number 14, I am appearing for the decree holder. My lord, today, my lord, my learned friend is appearing for the state. His SLP has been dismissed by the Supreme Court.
This
is the order, Lordship. My lord, I have filed a compilation. In that compilation, this order is there. If the judge said to compile,
This comes to the second page. The honorable judge had recorded that he had serious reservations with regard to the correctness of the judgment. Now, what has happened, what I understand, what I've been given to understand is that there were some issues relating to the obtaining the certified copies on basis of which the SLP was preferred.
Let us see what is the order.
Yes. As far as the merits are concerned, he had serious reservations.
Well,
Yes,
that means
yes.
the order has this is final.
Yes,
What
yes.
is the-
Now,
What was
we
the
have-
order
we have
was
been-
from the last occasion?
Yes, so
my lord,
That
your
is the-
lordship kindly come to page
we have been
7.
given.
Page 7, honor,
Okay,
of the
9
compilation.
September. 9 September time was granted.
My lord, that is
Dismissed. What is
my lord, on 21st of August 2025. My lord, at page 7 of the compilation. 7. My lord, this is your lordship's last order.
Yes.
Money is attached right now. Lying attached to lordship. Now, what I have been given to understand that the state is going to prepare a review application very soon.
My lord, on this ground,
No, I'm
my
not-
lord,
I'm
from
not-
April to August, the time the execution remains state. Now, my lord, the money is lying. My lord, your lordship kindly see,
How much money is lying with this thing?
my lord, kindly come to page 4, my lord. 13 crore, 94 lakh, page 2 of your lordship's order. Compilation, my lord, for your lordship's convenience, my lord, I have filed the compilation. Kindly come to page 3, my lord. That is the order dated 1st May 2025.
Comparison to copy purpose.
Yes. What May 2025?
My lord, paragraph 6, my lord. Let there be an order in terms of prayer B of the tabular statement in execution case. The judgment dated opposite party is refrained from operating the bank account maintained with Reserve Bank of India, BBD Work, Kolkata, in the name of and negotiate collectors account without setting apart the sum of rupees 13 crore 94 lakhs 2003. My lord, that money is lying. My lord, this
Now, the
order,
Registrar General was directed.
my lord, that part of the order is implemented. My lord, that security amount,
submitted.
yes, that security amount is already paid during the pendency of the execution, and I have given credit of that amount which I have received from the Registrar General. My lord, so far the Registrar General, my lord, kindly come to the compilation, my lord, at page 10. My lord, I've given the statement, page 10. My lord, the first figure 20 crore 91 lakhs, your lordship will get it from the tabular statement. That is up to 31st March 2025. Total decretal dues is payable this. Then, my lord, the second item, 2/3 amount thereof payable to Shiladitya Banerjee and Arundhati Chatterjee, holder number 1 and 4. Three is joined subsequently. I have not, yes, I have not given any amount due to, but the similar 1/3 amount is payable to decree holder number 3. Well, so for decree holder number 1 and 4, to file the execution, their total dues is 13 crore 94 lakhs 3,711. That exactly this amount is lying in a separate account by the Reserve Bank of India. Now, my lord, on 22nd of July 2025, decree holder number 1 and 4 received from Registrar General the part payment of the
191 lakh.
Yes, we have received. We have given credit. Now, my lord, till 31st of March 2025, 12 crore 2 lakhs 97,749 is due and payable. Now, my lord, this amount to be divided into two parts and to be disbursed by the Reserve Bank in the name of the different decree holder number 1 and 4. My lord, that is mentioned in the last portion of this page 10. The Reserve Bank of India to make payment to Shiladitya Banerjee 6 crore 1 lakh 48 and to be paid to Arundhati.
Reserve Bank to make.
Well, the last part of
Shiladitya Banerjee, that is decree holder number
1. And decree holder number 4 is, my lord, Arundhati Chatterjee. My lord, they are entitled to get the similar account out of the attached sum, and the direction, my lord, I am praying for against the Land Reserve Bank of India to make payment that amount out of the Land Acquisition Collector's Account Requisition. That is the name of that account where the money is lying.
Lord, may I quickly indicate from our affidavit, I support my learned senior friends, my lord, respondent number 3. The petitioner number 3, my lord, here.
My lord,
for decree holder number 1 and 4.
We are for decree holder number 3, my lord.
If it, decree holder number 3, I have no objection, my lord, but his money is not kept in a separate account by the Reserve Bank. And your lordship kindly pass the order of the Reserve Bank so far part payment is concerned for the similar amount of.
Question is he a party? You are decree.
We are a decree holder, my
He
lord.
has been added.
I'll quickly indicate, not kindly take up
Fine,
my
yes.
affidavit, which is separately filed. I'll indicate 2 paragraphs from there, which will clarify, my lord, the position. Only this. Wait.
What is that affidavit?
It's our affidavit of my lord, Aditi Mukherjee. It's formed on 11 July, my lord. Lord, you will kindly take up paragraph 13, page 7. Page 7, my lord, paragraph 13. There, my lord. I respectfully state and submit that in compliance of the judgment, decree and order passed by the Honorable Division Bench, their lordships an aggregate sum of rupees 20 crore, my lord, which is the figure which is matching, my lord. 20 crore 91 lakhs together with interest has become payable by the respondent. Kindly mark this, my lord, of which a sum of 6 crore 97 lakhs 1,855 is payable to me and to my account towards the legitimate share in the property acquired by the state and consequentially my share in the compensation amount. So this paragraph is the most relevant, my lord. And thereafter kindly take up the next page.
This is the GA.
Paragraph 17, my lord.
The tabular statement.
Now the difficulty, my lord, is also indicated in paragraph 16. Kindly take up that, my lord, paragraph 16 once, the previous page, my lord. It starts from the bottom of paragraph 16. The reason why the urgency. My lord, the petitioner here, my lord, is an octogenarian. The decree holder, my lord, number 3. Lost prime years. This, my lord, kindly see, this is waiting for more than 30 years back. And thereafter, paragraph 17, that's the difficulty they are facing.
Okay. So, as per the decree, you are entitled to 6 crore.
6 crore 97. That, my lord, is reiterated in paragraph 17.
1 and 4 is entitled to this 6 crore, this thing. 1 and 4. That is 13 crore.
We are
You are for
3.
Similar amount.
Similar amount, my lord.
From Registrar General, all the 3 decree holders have already received the part payment of the decretal dues. His client has also received. I have given in the compilation, my lord, in page 10, I have given credit of that amount. He should also give credit because he has also been paid.
Lord, paragraph 17, kindly take up, my lord. I'll not trouble your lordship after this, my lord. Page 8, paragraph 17, my lord. Respectfully state and submit. Instant execution application be allowed. Forthwith, my lord, kindly see the figure given here in the second last, my lord, line. In respect of the instant execution petition, I humbly submit appropriate order should be passed by the court forthwith for disbursement of 6 crore 97 lakhs to my account so that justice be rendered. No, this is the figure. But I am praying today for disbursal of this sum. Not any delay in disbursal. But in the facts which are stated and narrated in paragraph 16.
No, your amount is not separated in terms of the earlier order, probably.
It's same, my lord.
To degree holder number 1 and 4, it is kept separate.
No, it's the same because my lord,
No, no. With regard to order, I am just telling. I'm just
the order passed by your lordship, my lord.
Yes, it was confined to decree holder number 1 and 4.
It should also be covering us, my lord, because
He was not there. Who is 2?
My lord, the mother who died.
Okay. So this order with regard to the amount due and payable with decree holder number
3, my lord.
3, that order was not there. So that could not be done.
That amount is not lying as a security, my lord, is a reserve bank. Only the amount 13 crore 94 lakhs is the due and payable to degree holder number 1 and 4.
No, I'll indicate.
For 1 and 4 are
You could also get the similar amount
yes,
of.
but that amount is not
secured.
Is not segregated.
Probably not. They need to file a fresh execution, not because they are not petitioners here.
No, we have been added. Lord, can you take up the order of 10th June 2025? Perhaps that's why, my lord, we were not covered because in previous day to my lord, we were not party. Can you take up your 10th June 2025? So our petition for addition as a party here in the execution was allowed by this order, my lord, which has not been objected to by my learned friends. It's 10th of June 2025. My lord. And pursuant to this, we file a supplementary affidavit where we disclose, my lord, the figures.
Additional party order class. Additional party order class. Additional party will equal to 6 for an order class.
That's all.
My lord, so we are praying for disbursal of the amount today. At least, my lord,
We are, my lord, all on the same.
decree holders 1 and 4 after the dismissal of the SLP, nothing survives, my lord. The decree has to be satisfied as the executing court lordship was kind enough to give us, my lord, give them, my lord, time to, my lord, assail the order before the Supreme Court. That has been done. Now that they have failed, my lord, this is only a consequence of that. Kindly directs the Reserve Bank of India to, my lord, attach this account and disburse it, my lord, to the decree holders 1 and 4 directly.
Also decree holder number 3, my lord. We are on the same boat.
You have
And
not crossed the second phase. Let's just come to the second phase. Okay.
That's perhaps, my lord,
So,
because
we
are
are all straight away going to go to the third phase.
A direction on RBI to disburse the, my lord, amount due to decree holder 1 and 4.
Can be directive that we brought in the second phase.
but the difficulty, my lord, then we will stand, my lord, segregated. And my lord, that
Because you see, the earlier order was not there. Okay. It will take.
that's
some
because, my lord,
time.
we have come in on 10th of June. That's the difficulty.
Yes, Lord, may I first, Lord, make submission with regard to Mr. Bagh, Lord. Lord, he, Lord, may have been added as a party to the execution proceedings, but he is not the petitioner. Lord, if Lordship sees the cost statement, Lord, the petitioner are only, Lord, two of the parties, Lord, who are being represented by Mr. Sen. So, not in my respect, submission, they need to, Lord, apply a fresh note for execution, Lord, as far as their share is concerned.
But
And
for
there is
that,
no
my
attachment.
learned senior friend has to challenge the order of 10 June that they have not.
No, they have been added as a party.
We've been added as a party. We've filed a supplementary.
Lord,
We've
party
indicated the
respondent,
stand
Lord.
is only
Added as a party respondent, but he doesn't become the petitioner. Lord, he's been added as a party respondent, not as a petitioner.
Carried out.
Lord, we have filed a supplementary, my lord, because that was the direction.
Has the amendment been, your lordship sees, my lord, what is the
Amendment
amendment?
was not, because this issue had come up, my lord, where we had indicated, will through supplementary affidavit will indicate.
Yes, yes, my lord. Now, as far as my friend's client is concerned, your lordship not has seen the order of the Honorable Supreme Court. Not what had happened was not the learned advocate of the state not was handling the matter with the Honorable Supreme Court. Not he probably not had two sets of certified copies. Not he annexed the second one, and my lord, which has led the court, my lord, to believe that not a fair practice not has been followed. My lord, but the court has also recorded that they have serious reservation with regard to the correctness of the impugned judgment. Not only because not on the contention that the state did not, it was not because of the.
What happens to this
Yes,
judgment?
I'll tell you, lordship. So the state is taking steps. They will not apply for review. So what I'm submitting.
Interpret the purport of the order of.
No, I'm saying that we'll be. No, I'm saying we will apply for. Yes, I'm making my submission, but kindly, my learned friend, I will not interrupt my learned friend. So, what I'm respectfully submitting, if your lordship is inclined, to proceed with the execution, kindly, do not make the state remediless. If this amount is directed to be paid to them, let them keep that amount in a separate account for a period of 12 weeks, within which if I do not get any relief from Supreme Court, they can utilize that amount. But I think I'm making a very fair submission. But the money goes to them; it remains in a separate account, but for a period of 12 weeks, within which if I do not get the money, they can utilize it the way they want. I think that's a fair submission.
Yes, recorded.
But may I only
I'm
this
grateful.
before your lordship starts dictating the order? Lord, we have stated in paragraph 16 the difficulty and the urgency in our affidavit, my lord, which we have filed. It's page 7 and 8, my lord. 7 and 8 of. I believe this is the same protection which we transferred to the award holder 1 and 2 party to the proceeding. And Lord, the judgment also in our favor as much as it is in favor of the award holder 1 and 2. To kindly extend the same protection to us.
Yes, record an order. Learned advocate for degree holder number 1, degree holder number 2, and degree holder number 3 are present. Nice. On behalf of State of West Bengal, the judgment dated so that are learned advocates for the parties. Appeals that by order dated 1st May 2025.
One was I did just not interrupt. I saw a sum of rupees 1 crore 91 has been paid by the Registrar General to my friend's client. I yes, I do not know under by which order, because I did not find any
Order of the Honorable Division Bench disposed
Oh,
of.
I was not. Oh, I was not.
It was
Oh,
given, but unfortunately, Mr. Sinha was not there.
Appellate sir, I can't be there. I'm sorry. Yes.
Dated 1st May 2025. The judgment dated the party was restrained operating its bank account maintained with Reserve Bank of India PKD Bank by maintained with Reserve Bank of India PKD Bank Kolkata the name of and acquisition collectors account acquisition capital B stroke capital A account number.
My lord will kindly not mention the account number. We have been given to understand that this P/L29, it's no longer there. It's only in the name of the account.
Whatever it is, whatever there is in the earlier order, I'm just quoting.
Right.
Number 29, without setting apart sum of rupees 13 crore 94 lakh 3,711. Stop. Thereafter, notice was issued upon the judgment date. On the prayer of the learned, advocate of the judgment dated, the matter was to obtain necessary orders from the Honorable Supreme Court. It is submitted by the learned advocates and advocates that the special leave petition which was filed against the order of the Honorable Division Bench is already dismissed. Learned advocates for the judgment data state relies upon the copy of the order and submits that said special leave petition is not dismissed on merits, but on the ground that the Honorable Court has not invoked the extent of plenary jurisdiction for the ground stated in the said order. Stop. Learned advocate also submits that this client intends to file a review application. Upon perusal of the order of the Honorable Supreme Court, this court is of the view that once the special leave petition is disposed, nothing remains to be decided, and there is no ground for this court to further adjourn it, as it briefed for by the learned advocate for the decree order number 1, 3, and 4, that payment be made to the decree holders by the Reserve Bank of India, and it is suggested by Mr. Sinha, learned advocate for the state, that the payment be made subject to the condition that they be kept in a separate account and not liquidate the same for a period of 2 weeks, 12 weeks. To enable the judgment data to file a review petition, this court is of the view that in the interest of justice, there should be a direction upon the Reserve Bank of India to make payment of rupees 6 crore 1,48,874 each to both decree holder number 1 and decree holder number 4.
Kindly mention the name, my lord.
Decree holder number 1,
Shiladitya Banerjee.
Shiladitya Banerjee, decree holder number 1, Shiladitya Banerjee, and decree holder number 4,
Arundhati Chatterjee.
Arundhati Chatterjee. Such sums, upon being received by the Reserve Bank of India, shall be kept in a separate separate account of any nationalized bank, and the same shall not be liquidated for a period of 8 weeks without the leave of this court.
8 weeks.
Well, it should be from
10 weeks, not 10 weeks from the date of receipt. 10 weeks from the date of receipt, not 8 weeks, not
8 weeks from the date of the transfer.
8 weeks from the date of.
From the date of the transfer.
Very well.
Okay.
But I think we should.
My lord, from Reserve Bank to
the account.
The account of the judgment. To the account of the date.
After the decree holder has received the said account, he should invest in an account of the
8 weeks, my lord. Not 8 weeks.
No, I had asked for 12 weeks. My lord has given 8 weeks.
I'm giving him 8 weeks.
My lord, I think this last sentence which Lordship just now dictated, my lord, it has gone down as money received by Reserve Bank of India. I think that has to be corrected.
This is from Reserve Bank.
Upon receipt from the Reserve Bank of India
By the decree holders.
by the decree holder number 1
Yes.
and upon being invested account of a nationalized bank shall not be liquidated for a period of 8 weeks from the date of such receipt without the leave of this court. With regard to the decree holder number 3, the Reserve Bank of India is directed to keep separately rupees 6 crore 1,48,874. 6 crore 7 lakhs. Same amount. 6 crore 1,48,874 in a separate account and shall not operate the said account without the leave of this court.
Milord, Reserve Bank already has this money. I'm only praying instead of Milord segregating the Milord award holders, decree holders. Milord, may we be placed on the same boat in the previous Milord paragraph?
There is no
dictated by
attachment
Lord
here.
Pitt.
Just wait for some time.
The difficulty is
Okay,
Milord, if we-
liberty as a technical
Execution
point
file
is
to the-
raised by the judgment data, although the decree holder number 3 is made a party to this execution case, a liberty is granted to the decree holder number 3 to take out a formal application. This without prejudice.
That formal application in the instant proceeding, so that we don't have to file a separate execution.
You will
File
have
a petition here.
Probably you will have to file.
Supplementary affidavit.
Supplementary, my lord.
And you have
No,
filed a petition for addition of party or
That's
only
allowed.
simplicity
That's
supplement?
allowed. My lord, petition for filing,
Okay, the application, a necessary application for addition of party.
we have, my lord, and that's allowed, lordship. That's the 10th June order, my lord, which I've just handed over.
Okay, then it is not necessary. Let it only be segregated.
My lord, only one more, my lord, direction I was seeking. My lord, if the, my lord, respondent, the award debtor, fails to, my lord, produce an order of stay in this proposed review petition, then within 8 weeks, after 8 weeks, we would be at liberty to appropriate.
When will the matter appear? Let me fix the date.
Yes, not immediately after
May
notification.
9 p.m.
Because we don't know when the money would be remitted. Lordship has said 8 weeks from the date of transfer.
Open in the vacation.
No,
Okay.
that-
That is it. So
that-
your lordship is keeping
that is
it-
there,
they
my
are
lord.
opening, my lord, on 27th. Your lordship may keep it on, lord, 6th November, my lord.
Let this matter appear on 11/11/2025.
Great.
Should be one line be added, my lord, after, my lord, recording that they are keeping the matter, my lord, the amount segregated. But may we have the liberty to file an application for being, my lord, for the same order which is placed in the previous paragraph for award holders 1 and 4. Kindly grant us that liberty, my lord, we'll come up with that application before.
Lord, let them at least first not carry out the amendment, Lord, the addition of party, Lord, let the amendment be carried out first, Lord. They are still on, not even on record.
Be taken by my learned. And that will be, my lord, permitted to file an application for, my lord, necessary orders in the proceeding.
Liberty is also granted. I have already recorded.
My lord, that part, my lord, has been
বলুন তো ওখানে decree holder number 3 দেখবেন।
but that will not be required because, my lord, that has already been allowed by your lordship.
Addition of party take anything? Formal necessary order. Petition with regard to direction of payments.
I'm very deep, your lordship. Very deep.
File a report also. On the next day, the decree holders shall file a report of the compliance. That
We'll
that
file-
you have kindly give separate account.
My lord, to communicate your lordship's order to the Reserve Bank.
Communicate. I will take a copy.
My lord,
Take a. Yes, all parties will act on the server copy.
Yes.
lordship.
In the interregnum, my lord, we'll file that application.
Yes.
Very deep, your lordship.
Here on behalf of the decree holder, there's a short, my lord, modification application your lordship will find in the
one.
A1. Now, this lordship kindly takes, my lord, that application. Once, my lord, and kindly takes, my lord, page 5 of the application. If you want to. Me? Lord, I'll just indicate to your lordship, my lord, what I am seeking, my lord. Correct. Kindly takes, my lord, page 5 for once. My lord, in a execution proceeding, your lordship was pleased to attach, my lord, an immovable property along with a car parking space that your lordship will find at page 6 of the order. Page 6, running internal page 2. Paragraph 6, the last line, along with the car parking space. This should not be there, my lord, because in the decree, this has not been, my lord, attached.
Modification of that order.
Yes, only to the extent that the car parking space should be deleted. So what I'm seeking today is, my lord, modification of your lordship's order of 1st July 2025 and 29 July 2025.
That is your prayer.
That is only my prayer. Only restricted to that.
Yes. Learned advocate for the decree holder petitioner is present. This is an application for modification and correction of July 2025. Passed in this execution case. Is submitted by the learned advocate for the degree holder that although order was passed. Okay, paragraph 6.
Yes, paragraph 6 and
Paragraph 6. Paragraph order was passed directing the receiver to inspect and take possession of the car parking space at premises number 4, Shakespeare Sharoni, Kolkata 7,71,000. But car parking space was not included in the said decree. Stop. Acts and circumstances. Petition stands allowed. Let the earlier order dated July 2025 and 29th July 2025 be modified, and let there be an order in terms of the C of the master summons dated 8th day of September 2020.
and with regard
The receiver and the parties shall act for such modification of the same.
and my lord, your lord, the receivers, my lord, the joint receivers visited, my lord, taken possession of the flat. The lordship has, my lord, directed the
Now, I think publication was also directed
yes,
to make.
yes, yes,
So necessary modification should be made.
yes. On 29 July, your lordship directed us for publication, but we
Necessary
could not.
modification, the receiver, I've also directed the receiver and the parties shall act upon such
Great,
modification of this order
Grateful.
and take necessary steps in this regard.
Grateful. So, my lord, only thing, my lord, the time to, my lord, make necessary publication in the newspapers will not be extended.
Time to make necessary publication in the newspaper extended till 24/10/2025.
Pardon me?
I'm keeping it after. No, I shall keep it before vacation.
If we have 20,
How much time do you require?
within a week. Within a week, my lord, I shall complete the paper publications.
Time to file paper publication is extended till 25/9/2025.
Grateful. And
okay,
yes.
Let this matter appear on 28/10/2025.
And in the meantime, my lord, I'm seeking further orders, my lord, with regard to, my lord, two things.
Yes.
One, my lord, when the receiver has gone, my lord, and attached the property, in his report, my lord, he has mentioned, my lord, certain movable properties, my lord,
Yes.
which needs to be auctioned as well. So that order, my lord, I'm seeking. The next order is, my lord, your lordship will also find,
Is there any separate application? In this application,
my lord, the immovables are there, my lord, inside the immovable property, and which, my lord, the list is annexed, my lord, to the report. So automatically, my lord, those movables, my lord, have to be auctioned. If nobody is coming to claim, in fact, my lord, the judgment debtors have not come up.
An inventory has
Yes,
to be made.
it has been done. It has been done. It is annexed to the receiver's report as well. Your lordship kindly takes, my lord, the receiver's report for once, my lord.
Question is, you see, it's better you file a fresh petition, fresh application, with if you want that, for auction of the movable. With regard to
My lord,
movable, I'm granting liberty. Matter will appear after vacation.
My lord, I tell your lordship, my lord, why I am seeking this order today. My lord, we have served the judgment debtors.
Yes.
The judgment debtors, my lord, are not represented. Nobody came, my lord. In fact, my lord, when the receiver took possession of the flat, my lord, nobody present. So, my lord, those movables are still lying over there. It has to be, my lord, auction. Otherwise, my lord, the person, my lord, an intending purchaser who will purchase the property will get the, my lord, those
On a receiver. No, with regard to auction, it will not be in the particular, it will not be covered by this advertisement of immovable property. A separate steps are to be
a
taken.
separate advertisement for the movables, as in terms of the list, my lord, attached to the.
On a receiver is also granted liberty to issue separate advertisement for auction of the movable property which is lying inside the suit premises.
Inside the flat, immovable property or the flat,
The
my
suit
lord.
premises,
Decretal property, my lord.
Inside the decretal premises.
Being, my lord, annexure R3 to the report of the learned receivers.
Being annexed here R3 to the report of the learned receiver. Let this matter appear on the date.
And yes, my lord, one more, my lord. I'm troubling your lordship, my lord. Your lordship has directed the learned receivers to go to the bank and find out, my lord, the particulars. My lord, your lordship will also find from the report the learned receiver has specifically written that the bank has, my lord, not, my lord, cooperating with the learned receiver. They only has, my lord, said that this much amount is lying. No particulars has been furnished to the learned receiver in spite of the fact that there is a specific order.
The learned receiver is also permitted to seek report of the accounts lying the bank of the judgment. Which bank?
This is Axis Bank, my lord.
Axis Bank? Main branch.
Axis Bank, Calcutta main branch.
Calcutta main branch. And the bank authorities shall furnish the statements of accounts.
Grateful, my lord.
May it please, my lord. Appear for the defendant number 1, application for rejection of the plaint. Or affidavits are complete.
Filed my affidavit in opposition.
Our reply has already been filed.
Mr. Shuman, what that is bringing this matter. Question start if it's a complete.
Yes.
Pleadings are complete.
Let Mr. Ghosh start.
Yes.
Another date.
If my lord takes the application, the plaint is annexed. Straight away, I'll come to the point. At page 13. The page 13, my lord, the concise statement. If my lord comes to page 33, my lord, first. 34. 34, I'm sorry. The plaint, the prayers are there. Page 34. No, the next page. I think there's one page has been wrongly typed. Yes. At the bottom, my lord. The first prayer is decree for judging a letter dated such and such and an agreement dated such and such. That is not important. Then page 2, your lordship will have to come back to page 33. It's typed wrong one. Yes. Then prayer B is for specific performance of an agreement dated 15th December 2008. As mentioned in paragraph 26. Between the plaintiff and the defendant, directing the defendant to execute deed of conveyance in favor of plaintiff in respect of 12.5% in the premises. This is important, my lord. Number 3, Barapulia Road, Nizamuddin, New Delhi. So the premises is in New Delhi. Now, if my lord comes to page 35, that's the press C, they are wanting a mandatory injunction directing the defendant number 1 to execute and register a conveyance in respect of a property in New Delhi.
So is it a suit for specific performance or a suit of land?
Yes,
the question.
It is a suit for land. It is a suit for specific performance.
To be dismissed on ground of Order 7, Rule 11. That is, with the court not having territorial jurisdiction.
Yes, absolutely. No territorial jurisdiction. But it's a suit for land, and they have specifically asked for a mandatory injunction to register and execute and register a conveyance. I'll show my lord a judgment that this registration cannot be done in Calcutta. This registration also, the press C especially, has to be done in New Delhi. And they are seeking, my lord, specific performance of an alleged oral agreement. Now, that is a different point. I'll come to the other points. My first point that I'm urging is it's a suit for land. No leave under clause 12 has been obtained, nor can be obtained, and it is liable to be dismissed as barred by law. Now, if my lord comes back to the plaint, if my lord comes to page 17, Here the history is given. And I'm just one or two paragraphs I'll trouble, my lord. By registered conveyance dated 22nd August 94, the premises number 3 Barapulia Road, Nizamuddin, New Delhi, was sold by the owner such and such to MK developers. This is defendant number 3, and Green Acres properties, which is the defendant number 1. So this property was sold to MKJ and Green Acres. Now, my learned friend's contention is that the paragraph 2, on 24th August, an agreement was entered into by Green Acres Holdings, that's defendant number 1, and Belvedere, that's the plaintiff here, whereunder the defendant number 1 agreed to sell and Belvedere agreed to purchase 50% of the share of defendant number 1. Now, this is the not an agreement which they are seeking specific performance of. Because this, if it was, it would have been clearly barred by limitation. 1994, the suit has been filed in 2009. So this is just the history I'm giving, my lord. So there was an agreement in 1994. Then, if my lord comes to paragraph 7, page 20. Now, a new agreement was entered into. On the 12th of December 1996, another agreement was entered into between Greenacre, the defendant number 1, Ishan Housing, the defendant number 2, wherein Belvedere Commercial and the plaintiff, ITC Classic Finance and ITC Classic Real Estate, were confirming parties. Under the agreement of 12th December 96, the plaintiff, ITC Classic Finance and Real Estate, agreed to, plaintiff, that's Belvedere, agreed to give up all their right interest over and in respect of the premises number 3, Nizamuddin, Barapulia Road in Nizamuddin. So 1996, a new agreement was entered into. The plaintiff gave up all its rights. Now, the case in this suit is that this agreement of 96 has been given a go-by, so their right has renewed, as it were, and then there was a allegedly oral agreement held in Calcutta. There was a meeting held in Calcutta, and we have agreed allegedly to sell them 12.5% of the share. So, as far as the suit for land is concerned, my lord, my learned friend's contention, I'm presuming, will be that they have not sought for possession. But from the plaint, your lordship will find they are not in possession. Admittedly, they are not in possession of the premises. If my lord is still on the plaint. Yeah. My lord now comes to page 28. A lot of history in this. Now, this is the agreement, paragraph 26, which they are claiming specific performance of. Paragraph 26 at the bottom. Yes. On 15th December 2008, the defendant number 1 at his registered office at 37 Jawaharlal Nehru Road within the jurisdiction held a meeting with the plaintiff, wherein the defendant number 1 acknowledged that the plaintiff has an undivided 12.5% share. But how he can have I can acknowledge something that has never been executed and never been transferred is another issue, but the pleading is like that. And that the defendant number 1 would only transfer its 25% share in the premises number 3, Barapulia Road, and the undivided 12.5% of share of the defendant number 4 in favor of the defendant number 3. The defendant number 1 agreed that necessary conveyance in respect of 12.5% of the premises would be executed by defendant number 1 in favor of plaintiff. So this is all they have pleaded. Even the consideration is not pleaded. That will be another point of mine. If an agreement, a specific performance of an agreement is sought, the particulars have to be given of that agreement. Who entered into this agreement? It's not clear from this paragraph. Who represent? After all, both are private limited companies. The personnel are not given. What the authority was not given. And most importantly, the purchase price is also not given. So that's on that would be a point. If it survives, the if my learned friend survives the first attack, my lord, that this is in respect of a property outside the jurisdiction. Now, the two things, my lord. One is that the the plaintiff is not in possession of the property. If you are in possession of a property, then it's only a question of execution of, if the agreement is specifically performed, then the conveyance has to be done. If he is not in possession, then automatically a suit for specific performance
First of all,
includes.
if this court does not have the jurisdiction,
Yes, I'm on the jurisdiction first.
in both the proper remedy is Order 7, Rule 10, that is the proper
Yes,
remedy.
that can
No question of plain being rejected. Order 7, Rule 10 has to be invoked. If this court does not
If-
have any jurisdiction,
yes, I bow down.
court will not go into
Yeah.
the merits.
I bow down to that. Then, but that is inclusive. That is also in my prayer. That can be done.
The moment the court is satisfied that this court has jurisdiction, then only the court will proceed to consider the.
So I am only on the first point, that the court doesn't have jurisdiction. Since your lordship, I'm taking my lord through the plaint. I'm saying these are the other glaring issues that there are. Is that it is also, there are no particulars. It's an alleged my lord, oral agreement, and as per the CPC, particulars have to be given. I'll satisfy my lord on that issue as well. But your lordship has to decide both. Of course, if your lordship decides your lordship has no jurisdiction, I have nothing to say. Then the plaint goes. Now, if the distinction, now if my lord takes a decision, the distinction I want to draw is, first of all, from the plaint, it is clear that they are not in possession of the property. This is number one. If they are not in possession of, and they are seeking specific performance, it implies that they are seeking possession. Even though there is no prayer in the plaint, as it were, that give me possession, it is implied. I'll show the decisions on that because of the provisions of the Specific Relief Act. It can be amended at any point of time, the plaint, and that prayer for possession can be included, whether after the decree or before the decree. So, it has to be assumed that they are not getting possession. But I am on it's a clearer point which is particular to this particular case. Prayer C, page 35. My lord will mark that prayer. They are specifically asking for a mandatory injunction to execute and register a conveyance. This conveyance can only be executed and registered in New Delhi and not in Calcutta. And for that ground alone, this court has no jurisdiction to grant such a prayer. Now, on this, I want to show my lord a judgment. Now, this is I have the Manupatra version. I have the copy. Reported in Manupatra 1277 of 2024. Rohit Kochar versus Vipul Infrastructure. If my lord takes the third page, my lord. Yeah, third page. Where the order begins. Yes, order. These petitions arise from a common order passed by the division bench of the Delhi High Court, by which the appeals filed by the respondent herein came to be allowed, and the plaint was ordered to be returned to the petitioner herein for presenting it before the appropriate court having territorial jurisdiction to try the same. So the single judge had rejected the application under Order 7, Rule 11 or Order 7, Rule 10, and the division bench ordered that the plaint should be returned. And this is the appeal. But the appeal was dismissed, and it was held that the court did not have jurisdiction. Then my paragraph 2, the plaintiff, original plaintiff in such and such suit, filed the suit for permanent injunction and specific performance of a contract dated such and such, entered into between the respondents and the original defendants in connection with the commercial property measuring so much square feet in Gurgaon. Then in it is the case of the plaintiff that sometime in 2003, the original defendant number 2 offered to sell the commercial space of 10,000 square feet on the second floor of a commercial complex. Now, these are not really important. Then my lord will come to paragraph 8. Those are the facts of the case. The written statement has been filed. Then paragraph 8. The learned judge, by an order dated 25th April 2005, overruled the objection raised by the defendant as regards territorial jurisdiction and took the view that it had jurisdiction to entertain the suit. The court took the view as the plaintiff was seeking relief of specific performance simpliciter and had not prayed for a decree to put him in possession of the property. Such a relief could be granted and enforced by personal obedience of the vendor, and thus the court in whose territorial jurisdiction the vendor resides or carries on business or works for gain would have the jurisdiction to entertain the suit. So this was the reasoning of the single judge, paragraph 8. Then the single judge relied on this decision, Adcon Electronics and Daulat in 2000, reported in 2001, 7 SCC. But here the distinction had been made. If possession is not sought for, then it need not be a suit for land. If it was merely asking for a personal obedience to execute a document. But this decision, my lord, of Adcon did not rely on a earlier Supreme Court. This is also a Supreme Court decision I'm citing before, my lord, which they distinguish later and say that the earlier decision of 1982, Babulal's decision, my lord, there it's made clear what is the implication of section 22. I'll place paragraph 9, since my lord is reading that. Placing reliance on Adcon, the single judge drew a distinction between a suit relating to specific performance of a contract for sale of immovable property simpliciter and a suit where additional claim for delivery is made, and observed that a suit in the former category, that is one for enforcement of a contract for sale and execution for conveyance, cannot be said to be a suit, determination of a title of land or the decree in it would operate as land, on the land. The court further observed that under section 22 of the Specific Relief Act, it has been specifically held to be an enabling provision by the decision of Adcon. And thus, observations made by this court in Babulal versus Hazari Kishori Lal, 1982, would not be applicable to the facts of the present case as the issue was directly answered by Adcon. But this is the finding again of the single judge. Now, this was overruled by the division bench and the Supreme Court later in this decision. Now, then it's the rest of paragraph 9 is a quote from the single judge. I'm not reading that one. If my lord turns over the page, paragraph 10. The defendants, being aggrieved by the order of the single judge, preferred 3 appeals to the division bench. Then 11. Division bench allowed the appeals and ordered the plaint to be returned in accordance with law so as to be presented before the court of competent jurisdiction. The division bench, in its impugned order, took into consideration the provisions of section 16 and also section 55 of the Transfer of Property Act and recorded as follows. And I'm just placing this for the fullness of the argument. Then, in the present case, it is an admitted position that the appellant had entered into the alleged contract at its corporate office at Delhi. It is the specific stand of the appellant that they were initially residents of Delhi and they had moved to Gurgaon, and their corporate office is now located at Gurgaon. It is the contention of counsel appearing for respondents that the proviso to section 16 of the CPC is applicable, which is sought to be invoked for the relief which is sought for the entirely enforced through personal obedience of the defendants in Delhi. There is, however, not only a prayer in the plaint for declaration of right title, but also to transfer the right title and interest in the suit premises at Gurgaon. As in our opinion, a suit can be decreed in favor of the plaintiff only when the court can get the sale deed executed and registered in favor of the plaintiff, which would confer the title of the suit premises on the plaintiff. The execution and registration of the sale document would have to take place at Gurgaon, And for this, the court will have to pass a decree directing the defendants to get the sale deed executed and registered at Gurgaon. Implication of the same will be that a direction will have to be given to the defendant that he shall move out of Delhi and go to Gurgaon and get the same registered. No sale deed is sought to be registered at Delhi, and therefore, in our considered opinion, such relief cannot be entirely obtained through personal obedience of the defendant, who in this case has to go to the jurisdiction of another court to get the decree executed and the sale deed registered. So, my lord, in this place, if you substitute Delhi from Calcutta, that's the only difference.
The registration cannot be done at Calcutta.
Cannot be done. And they've asked for mandatory execution and registration of the document.
It cannot be done at Calcutta.
Cannot be done. And therefore, the division bench held that it is implied in a decree for specific performance. Of course, section 16 of CPC is referred to. In our case, it will be clause 12 of the letters patent. But if the language is the same, if it's a suit for land, then, my lord, the property is situate outside jurisdiction and no part of it is within the jurisdiction of this court, then, my lord, this court cannot have jurisdiction. So this argument I will be relying on. Now I'll place the rest, my lord. Paragraph 18. No, this is the division bench decision which has been upheld in this matter. Then 19. Accordingly, we are of the considered view that the submissions made by the learned counsel for the respondent, that the findings recorded by the learned single judge, that the present case is covered by proviso 16 of section 16 to CPC are misplaced. In the facts and circumstances of the case as delineated, the relief in the present suit cannot be entirely obtained through personal obedience of the defendant. The proviso to section 16 of CPC would be applicable to the case where relief is sought for by the plaintiff was entirely obtainable through the personal obedience of the defendant. That is, the defendant would not at all to go out, has not at all to go out of the jurisdiction of the court for the aforesaid purpose. The present case is not a case of the aforesaid nature. The present case, for execution of the sale deed, the defendants will have to go out of the jurisdiction of this court and get the same executed and registered in Gurgaon. In the present case, it is an admitted position that the possession of the property was with the seller. Therefore, in terms of the provisions of section 55 of Transfer of Property Act, the relief of possession is inherent in the relief of specific performance. This was the other point I told my lord, that they are not said that they are in possession of this property. So when they seek specific performance of an agreement for to sell this property to them, it is inherent that the relief of possession is in there. In our considered opinion, the ratio of the decision of the Supreme Court in Babulal's case and the principles laid down in Harshad Chiman Lal Modi's case are applicable to the facts of the present case. In Harshad Chiman Lal Modi, it was found that in addition to passing the decree, the court was also required to deliver possession of the property. It was held that such a relief can be granted only by sending the concerned person responsible for delivery of possession to Gurgaon, and the court at Delhi does not have jurisdiction to get the aforesaid decree enforced for the property situate outside its territorial jurisdiction. So, assuming my lord passes a decree in this suit, the execution will have to be in Delhi. Then, the court, while referring to the provisions of section 16 of the CPC, held that the location of the institution of the suit would be guided by the location of the property in respect of which and for determination of any right or interest whereof the suit is instituted. The proviso to section 16 is also not applicable to the case, as the relief sought cannot be entirely granted or obtained through personal obedience of the respondent. Then, that ADCON is distinguished to this extent. The decision of the Supreme Court in ADCON relied on by the respondents would not be applicable on the facts of the present case. The decision rendered in the context of the expression suit for land. The Supreme Court in the said decision held that the suit for specific performance of an agreement of a suit property without a claim for delivery of possession cannot be treated as a suit for land and is triable under clause 12 if the other conditions thereunder are fulfilled. The facts of the case are therefore distinguishable and not applicable to the case in hand. The decision was rendered due to the specific provision therein, and it is apparent from the fact that the case of Babulal was not even referred to in that case. In another decision, the Supreme Court, which needs reference at this stage, is Begum Sahiba Sultan, reported in 2007 for SCC. In paragraph 12 of the judgment, it was held by the Supreme Court that the reading of the plaint as a whole in this case, there cannot be much doubt that the suit is essentially in relation to partition and declaration in respect of properties situated in Pataudi, Gurgaon, outside the jurisdiction of the Delhi court. In that view of the matter, it was held that the Delhi court will have no jurisdiction to try and decide the aforesaid suit. It has also been held that the decision, by following the decision of Harshad Chimanlal Modi, that the relief of partition accounting declaration of invalidity of the sale executed in respect of an immovable property situate in Gurgaon, Pataudi, could not be entirely obtained by the personal obedience to the decree by the defendant. It is further held that applying the test laid down, it is clear that the present suit could not be brought within the purview of section 16 or entertained relying on section 20 of the code. That 3 of the 5 defendants are residing within the jurisdiction. In view of the above circumstances, we have the concerned opinion that the Delhi court would not have territorial jurisdiction to entertain and decide the suit. Consequently, we hold the decision rendered by the single judge cannot be upheld. So this was the division bench. Now the Supreme Court decides on this decision and upholds this judgment. Then, having heard the counsel for the parties and having gone through the materials, we are of the view that no error, not to speak of any error of law, could be said to have been committed by the High Court in passing the impugned order. Then, madam, section 16 is discussed. That is not relevant in our case. It's the same as clause 12 as far as this is concerned. Then 15. Thus, the pivotal question before us is whether the relief being sought by the plaintiff is in respect of the suit property can be entirely obtained through personal obedience of the defendant. If yes, then the facts of the present case would warrant an application of the proviso of section 16, and the High Court on its original side would be competent. So if it could be done only by the personal obedience of the plaintiff, of the defendants, without them having to go outside the jurisdiction, then the court may have had. But this is the Supreme Court saying, analyzing the earlier judgment. This court in Harshad Chimanlal Modi reported in such and such, observed that section 16 of the Code of Civil Procedure recognizes a well-established principle that actions against res or property should be brought in the forum in which the res is situate. A court within whose territorial jurisdiction the property is not situate has no power to deal with and decide the rights interests of the property. In other words, this court held that a court has no jurisdiction over a dispute which it cannot give an effective judgment. On the proviso of section 16, the court observed that the proviso no doubt states that though the court cannot, in the case of immovable property situate beyond jurisdiction, grant relief in rem, still it can entertain a suit where the relief can be obtained through personal obedience of the defendant. One rider I'm putting here, that section 16 is not applicable to our High Court. Section 16 to 20 of the CPC is not applicable to chartered high courts. That's section 120. Your Lordship will just keep a note of that. That section 120 of our CPC says that these particular sections are. So the principle is in clause 12. And there's no proviso to like this in clause 12. In any event, it doesn't apply to our facts then. The proviso is based on a well-known maximum, equity acts in personam, recognized by the Chancery courts in England. The equity courts had jurisdiction to entertain certain suits relating to immovable property situate abroad through personal obedience of the defendant. The court observed that the principle on which the maxim was based was that the court could grant relief in suits relating to immovable property situated abroad by enforcing their judgments by process in personam, that is, by the arrest of the defendant or attachment of his property. The court held that a suit for specific performance and delivery of possession was covered under Clause D of Section 16, and thus the parties, even by agreement, cannot confer territorial jurisdiction upon a court within whose territory the subject matter is not situated. We cannot confer jurisdiction. Then recently, the court, in the decision of Baba Saheb Dhundiba 2024, has held that the conveyance by way of sale would take place only at the time of registration of a sale deed in accordance with Section 17. Till time of such registration, no conveyance could be said to have taken place. Thus, even in a suit for specific performance if a suit for specific performance is decreed without a specific decree for transfer of the possession of the suit property, the same can be enforced only when the trial court directs the defendant to convey the suit property to the plaintiff by getting a sale deed registered with respect to the property, as it is only after registration that the transfer of title would take place from the defendant to the plaintiff. The registration of the sale deed in the present case would have to take place at Gurgaon, as the suit property is situated there. The sale deed is not sought to be registered at Delhi, in our case not in Calcutta, and the implication of the grant of specific relief would be that the trial court would have to direct the defendants to move out of Delhi, go to Gurgaon to get the sale deed registered. As rightly held by the division bench of the High Court, such relief cannot be obtained entirely by personal obedience of the defendant, and the defendant will have to go to the jurisdiction of another court to get the decree executed. We agree with the view expressed by the High Court in the impugned order that the proviso of Section 16 would be applicable to a case where the relief sought by the plaintiff can be obtained through personal obedience of the defendant. That is, the defendant who has not to go out of the jurisdiction of the court for the purposes of grant of relief. However, since the present case would require the defendant to go out of Gurgaon, go to Gurgaon for execution of the sale deed, based on the proviso to Section 16, will not be applicable. Then 22. It is necessary to understand the import of Section 22 of the Specific Relief Act for a better appreciation of the issue before us. The said provision provides that any person suing for specific performance of a contract for transfer of immovable property may, in an appropriate case, sue for possession or partition or separate possession of property in addition to performance. It is further provided in subsection 2 of the said provision that no relief under the provision shall be granted by the court unless it has been specifically claimed, provided that where the plaintiff has not claimed such relief in the plaint, the court shall at any stage allowing the proceedings allow him to amend the plaint on such terms as may be just for including a claim of such relief. So in this case, my lord, even if my lord gives a decree of specific performance, they can come back and amend the plaint after the decree also, but under the provision of Section 22, and include the power, the relief for possession. So now they will oppose my prayer for saying it's a suit for land, but at that time they can always change it. So because they are not in possession, if they were in possession, it would be a bit different. AdCon would help them, I think. Now, this is important. This was mentioned in Babulal's case. This is the 82 Supreme Court, an earlier decision, 23. This court in Babulal, upon a combined reading of Section 22 and Section 28(3) of the Specific Relief Act, respectively, and Section 55 of the Transfer of Property Act, observed that it was only in an appropriate case that the plaintiff was required to separately seek relief of possession, partition, or separate possession, as the case may be, along with the relief of specific performance. The court observed that in other cases, for example, a case where exclusive possession of the suit property is with the contracting party, a decree for specific performance for contract of sale simpliciter without providing for delivery of possession may give complete relief to the decree holder. This, the court observed, was the mandate flowing from section 55. Relevant observations made by the court are extracted below. Then, Manoj Babulal's case is set out explicitly.
With regard to specific relief act.
Yes, so here also the argument is that since they are not in possession of the property, the prayer for possession is inherent in a claim for specific performance. And this is the Supreme Court decision which explains when this provision was included. I think section 22 came in afterwards, and this provision allows them to include a prayer for specific for delivery at any stage. I'm not placing the decision of Babulal which is quoted, though it's relevant, but your lordship come to paragraph 24. This was not considered in such detail in the ADCON case. Section 22 of the specific relief was considered by this court in ADCON. The court was called upon to interpret the expression suit for land appearing under clause 12 of the letters patent at Bombay, and whether the suit for specific performance simpliciter, where no prayer for possession was made, could be a suit for land within the meaning of the said clause. The court referred to the decision of the 5-judge bench in Mulji Jetia, 1950 FC 83, and observed that there's a difference in opinion as to the import of the expression suit for land. Inter alia, the court expressed its agreement with the following observation made by Justice Mahajan. In my opinion, if the suit is for specific performance and a decree for possession of land sold is claimed, such a suit would certainly be a suit for land. But a suit simpliciter for specific performance, for the enforcement of a contract of sale and for execution of a conveyance, in that event can be no good ground for holding that such a suit is a suit for determination of title, and it would operate on the land. Then the court further expressed agreement with the full bench of Madras. I'm not quoting that. Now, if my lord comes to paragraph 27. Further, on the aspect of section 22, the court took the view that although the provision is an enabling in nature, yet as per the mandate of subsection 2, the relief of possession of immovable property, which is the subject matter of the agreement for sale, cannot be granted by the court unless the relief for possession is specifically prayed for. The relevant observations are extracted below. This is again from ADCON.
It's concerned what relief the court can grant.
Yes.
That is specifically provided.
Yes. So they can always ask for possession under section 22.
This suit, did they ask for possession? No. This suit.
No, they haven't asked.
They
But
haven't
if they were in ADCONs, what they say is, if they were in possession, they need not ask for possession. Then you can ask for, you execute the conveyance. I've already got into the property. I can ask the person that in personam you execute the conveyance.
Whether he comes from Delhi or
Yes, yes. No, that is the point. No, that is the point in our case. I'm coming to that, Manoj. Now, after distinguishing these judgments and explaining the law, my lord, the Supreme Court goes on the finding of this case. Let me show you, my lord. Paragraph 32. My lord comes to paragraph 32. In the present case, the alleged contract for sale was executed between the parties through exchange of communications, respectively, dated such and such, contains the stipulation that 10% of the sale consideration has to be paid immediately, 85 to be paid on such and such, and the balance to be paid at the time of notice of possession. Further, there is a stipulation that the possession has to be handed over by the defendant upon the payment of the balance 5% of the sale consideration. Further, section 55F 1F of the Transfer of Property Act stipulates that a seller of immovable property is required to hand over possession of the property to the buyer pursuant to the execution of the sale deed. It is also held in Babulal that in view of the interplay between section 22 and 28 of the Specific Relief Act and section 55, the handing over of possession of immovable property in respect of which a decree of specific performance has been granted is only incidental. Thus, it is clear from the terms of the alleged contract between the parties that the transfer of possession of the property is implicit in the contract, and the absence of a specific prayer for seeking transfer of possession would not have any bearing on the character of the suit, which is covered by 16D of the CPC. So in our case, suit for land. If we were to hold otherwise, it would give rise to a situation where the plaintiff would be allowed to file a suit for specific performance simpliciter, and having obtained a decree therein, the plaintiff would pray for transfer of the execution proceedings to the court within whose territorial jurisdiction the property lies, and thereafter seek amendment of the plaint to include a prayer for transfer of possession, which has been expressly held to be permissible in Babulal. An interpretation which gives rise to the possibility of such misuse of law cannot be allowed. For the aforesaid reasons, specially petitions fail and are dismissed. So, my lord, just to remind my lord once that after the division bench decision was set out, my lord, paragraph 13 was 13. The Supreme Court first affirms everything. Paragraph 13.
If a decree is passed, it cannot be executed outside the territorial jurisdiction. That
No,
is
no.
also
He's saying that it can only be. Therefore, you are misusing the law by not asking for possession now and asking for specific performance. So the court has held, no, if you're asking for specific performance, your prayer for possession is implicit. Unless you happen to already be in possession, then you obviously you don't need to ask for possession.
one is with regard to possession being implicit.
Yes.
And
the view of the division bench, which is upheld in paragraph 13.
The execution, assuming the possession is
No,
implicit.
you cannot pass a mandatory direction on the defendant to go outside the jurisdiction. He'll have to travel to Delhi, because without registration, a deed of conveyance is useless.
And that cannot be executed at Calcutta also. There is no
Yes, there is no such provision. So this is the main point, and there are some other points, my lord. I'll come back on that. But one important thing I need to say, I showed my lord the paragraph 1 of the plaint, where the property was purchased by MKJ Limited, defendant number 3 and defendant number 1. Then the defendant number 3 filed a suit in this court for specific performance, in which all these other parties, even Belvedere, the plaintiff, was a party. And in that suit, which related to the property in Nizamuddin in Delhi, my learned friend's client, the plaintiff, had filed a written statement and taken this very point, that the court has no jurisdiction. This relates to a property in Nizamuddin. That is at page, if my lord comes to page 140. Page 140 is the written statement of the defendant number 2. It begins a bit earlier, the cause title. 137, the 138, I'm sorry, CS 84. 138, the cause title begins. My lord will see that the defendant number 1 is the same, page 138. Yes. Defendant number 1, Greenacre, is my client. Defendant number 2 is my learned friend's client, the plaintiff in this suit. And this is the written statement of the defendant number 2, page 140. Your lordship will see paragraph 5. The plaintiff, yes, the plaintiff here, my learned friend's client. Paragraph 5. In any event, this honorable court has no jurisdiction to entertain, try, and determine this suit. Then, my lord, there is more elaboration. If your lordship comes to the last page of the written statement at page 144. Last sentence I'm reading. No, I'll read the whole paragraph. On the instant, suit is bad in law and liable to be dismissed. It is denied that on 6 September 2000, the defendant entered into any meeting, etc., etc. Last sentence one. It is stated that this defendant has undivided 12% right, title, and interest in the premises. The suit is a suit for land, and hence the honorable court has no jurisdiction in the matter, and the suit is liable to be dismissed. So of course, it's a question of law. My learned friend can argue otherwise, but his client has taken this stand. That suit got settled. That MKJ suit got settled. This is still pending from 2009. No steps. We had filed our written statement long ago. We had taken this point. No steps were being taken. We have come to we made this application, my lord, so that it is unnecessarily hanging on our title, this claim, because they will later say that it's lis pendens. They're just waiting and they're not pursuing the suit. And as far as an agreement, as I showed my lord the plaint, there is not, even the consideration is not given. I'll show a Supreme Court decision, my lord, will show that in a suit for specific performance, the particulars of the contract must be pleaded. I'll also show a decision that usually two private companies cannot enter into an oral agreement. If they can, and if they have to prove the oral agreement, they have to show that the persons negotiating were the authorized persons. By board resolutions, etc., they were authorized. But here there is absolutely no pleading of that. So I can show that, or I'll, if my lord wants, I can
conclude it on the next day.
On the next day.
It's for the party. Counsel for the defendant submits on GA7 of 2025, but could not conclude the second. Let this matter appear on 16/9/2025. 16. I got it down.
16th is next week.
18 also not.
16th, any day apart from 15th and 16th.
18/9/2025.
Then I'll conclude my submissions. Then my learned friend will do it before the vacation also.
You can conclude. We can start.
Conclude, then I'll start.
18th. 18th or 12:30 to 6. I'll manage. I have a matter fixed at 12:30 on the 18th, but I'll take my chance for it. I should be okay. Great.
Yes, call the next.
Next number 17 and 18.
Not today.
Your Lordship, I'm for the plaintiff.
17 and 18.
Yes, Your Lordship.
Yes.
17. Your Lordship, in GA number 12, all the pleadings are complete. Kindly fix it for hearing. 17, 18, 20, 21, 24. I'm for the plaintiff, sir.
18, 20.
17, 18, 20, 21, 24. I'm for the plaintiff, Your Lordship.
Advocate for the number 6. Plaintiff, learned advocate for the parties are present. The
After
prayer of
vacation, Your
learned
Lordship.
advocates. Matter be fixed on. Shall I keep it on 18 or some other day?
No, not on 18th. 18th, I'll be.
Let this matter appear on 23/9/2025. 16, 18, 21.
17, 18, 20, 21, 24.
4.
Take your order.
25.
Here for the plaintiff and all, and we are for respondent number 6.
Next number 19.
19, my lord, I am for the petition. The last occasion, my lord, your lordship was pleased to direct me, my lord, to serve upon, my lord, the respondents, my lord, through substituted service. That has been, my lord, completed. Nothing here. Maybe service. Lordship kindly takes up page number. There are 2 annexures, my lord, in 2 newspapers, my lord. Well, I'm the petitioner in the GA application, my lord.
The application for?
Application, my lord, for allowing me to substitute, my lord, on the caveators in substituted mode, my lord. Since, my lord, after the initial, my lord, after they filed a caveat, after that, my lord, disappeared. But I tried to contact with their, my lord, learned advocate on record, my lord. The learned
caveator.
For the caveator. The learned advocate on record, my lord, stated, my lord, that he is no longer appearing. And that's why, my lord, the application was taken out. Lordship kindly takes up, my lord, the affidavit of service, my lord. There are page 4 and page 5, my lord. My lord, page 3 and page 4, my lord.
Earlier order, that is 21st May.
Yes, 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 my lord. My lord, 24th of July, your lordship kindly takes up 24th of July 2025 order, my lord. My lord, I have annexed also, my lord, in the affidavit of service, my lord. Kindly, my lord, takes up page 6 of the affidavit of service, my lord.
4th of July.
My lord, learned advocate, my lord, may I read for your lordship, my lord?
So that is there. So that that petition was allowed and you are permitted to make paper publication.
Yes, yes, yes. That has been, my lord.
Made publication in
Yes.
which paper? Business Standard.
My lord, two newspapers, my lord. One is
Business Standard. There is
my lord,
Telegraph, that Statesman.
my lord, although my lord, Ajkal, my lord, also Ajkal, it has been, my lord, made. My lord,
Why? This is a commercial paper for this person who related to involved in the trade industries. This is not a. Why? Which paper is this one?
my lord, Ajkal.
Anyway, did I mention?
No, my lord, no. The name of the newspapers were not mentioned, my lord. My lord, the last line your lordship can accept, let publication be made in one English newspaper and in one Bengali newspaper after completion of necessary formalities.
Where was the caveator residing?
I'll just indicate. Caveator, my lord, was residing at Ultoranga Main Road, my lord, inside Calcutta, my lord.
Honored advocate for the applicant is present. Also, order dated 24th July 2025. Directing and granting the applicant to file advertisement, to file the notice in doing one in English and one Bengali newspaper. And has made the publication in two newspapers, namely the Standard and Ajkal. Considering the newspapers in which publication is made, this court is of the view that these two newspapers are not widely circulated in the areas where the petitioner lastly resides. Although a direction could be made to make further publication in two specified newspapers, but prior to making such direction, this court is of the view the caveator last appeared, it would be proper for an inquiry through a special officer from the residence where the caveator last resided regard to this matter. Thus, special officer, namely Dash, is appointed to cause inquiry as to whether the caveator is still residing at the present address. In the event it is at the present address, the event the caveator is residing at the present address, the copy of the application will be served by the learned special officer along with the order of this court with a direction appear on the next date fixed. special officer for notice to the learned advocate for the applicant. Calls the inquiry. Learned advocate for the applicant shall submit relevant documents, including the petition and the last address. Learned special officer. Fiction must be completed. 9/2025. Keeping it before vacation.
My lord. Well, only point out, my lord, from the track report, my lord, that was sent, my lord, it comes that the item return address is moved. Already, my lord, the track report is this. That has been annexed here too, my lord.
Let this matter appear on 26/10/2025. Sir, आगे दिए देवे. Caveat is not deciding. Steps shall be taken by inquiry as to the present address.
Grateful.
So item 22 and 23 appear for the petitioner. Let me file the sir rejoinder and serve a copy upon my learned.
My lord, I'm for the plaintiff and the respondent in the
22.
application.
Sir rejoinders, lordship.
GA11.
Yes.
Yes, my lord.
G11 and GA13, 22
My-
and 23. May I file the sir rejoinders, lordship, on the last
My lord, by
Whose application?
my application. The defendant numbers 1, 2, and 3.
Application for?
GA11 is for extension of time to file written statement, and GA13 is for recalling or modification of an order dated 25th of January 2024.
What is that order passed?
Lordship, on the 25th of January 2024, this learned court has been fixed to make the matter ex parte, proceed ex parte as against the defendant numbers 1, 2, and 3.
Affidavits are complete.
I will be
Yes.
filing the sir rejoinder.
Plaintiff,
yes, I'm for the plaintiff and
affidavits are complete.
No, Lordship. I will be
If
filing my sir rejoinder and then
Record an order.
my lord, by our lord's order dated 26th August, they were to file their reply to my rejoinder on or before 4th September. And they're
Lordship,
filing.
it is ready. It was ready on the
You have
8th of
filed the
September.
opposition and they are to file the reply.
Yes, yes.
There,
yes.
and we have
Are
filed the
they
reply.
for the
Thereafter, they
parties?
filed
They've-
rejoinder.
we've
This
filed
is
a
sir
rejoinder.
rejoinder to their rejoinder. There's a 4-day delay, Your Lordship.
Was used.
My application.
File the opposition.
We filed a reply. Then they wanted to
Then
file a
we filed
rejoinder.
a
to that.
rejoinder and then
So we are filing a
filed
sir
a
rejoinder
reply
to
to
their
it.
rejoinder.
Yes.
So request some time.
Yes, my lord. My lord may kindly fix it after vacation.
Lordship,
Mr.
that
Advocate,
Lordship
for
would
the-
kindly just record my objection to that. We want to
Advocate
finish it
For the parties are present.
this side of the.
Learned advocate for the plaintiff submits that he is receiving the rejoinder, the
Petitioner application.
opposition to the reply to the rejoinder.
This is yes. The
reply
sir
to the
rejoinder.
rejoinder today, and she requests some time.
Rejoinder.
Thus, this matter stands adjourned till
Lordship, there is some urgency. Lordship would kindly keep it on this side of the vacation.
the suit is there.
The suit is proceeding ex parte.
Ex parte against the
They
defendant
may
numbers
take the
1, 2,
benefit of this.
led by Mr. Daj.
Okay, 28.
Or let them give an undertaking they do not
Okay,
proceed.
28.
My lord, I am ready with the matter. Let my learned friend move the application here. And
Yes.
I am ready.
Lordship, may I file the sir rejoinder?
Let my learned friend move. Lord, they take time. They are out of time, and my lord, they are saying that there is urgency. They are the ones who wanted to file sir rejoinder.
What will be the difficulty? If it is
Difficulty is, I tell you, Lordship.
Yes.
This
When,
will be-
when is the suit due to appear?
Lord, any day it's appearing before your Lordship.
It will be before my lords only.
What heading? It is
Well, it's I am out. I have not. I have
not appearing in
refused.
the list.
The applications are there.
Very well.
Application
You
is in
can
the
pray also
If
for
not,
adjournment.
Lordship assures me that in this circumstance suit will not be proceeded, I have no problem.
আচ্ছা, ছেড়ে দিন, ওই order টা করুন। Let this matter appear on 28/11/10/2025.
28. 10.
28/10/2025.
Immediately after.
Let this matter appear on 28/10/2025.
So it is understood that they will not because expert it has been marked as expert against.
My lord, nothing has happened in.
When the matter will
My lord,
be
nothing has
closed,
happened in last 8
Wait
months,
for
and
it,
in my
sir.
learned friend expects in next 8 days something will happen. My lord, surprising.
My
Remind me if
my
Sorry,
sir rejoinder bill. I filed a sir rejoinder.
the rejoinder,
Sir rejoinder.
with the original rejoinder filed by the plaintiff and reply to the rejoinder by the applicant be kept with the record.
Grateful lordships.
Grateful.
The 22, 23 both men.
Yes, yes, both. It will appear on
28th
28th,
of-
28th.
both are my application.
Grateful, Lordship.
Separate করে দিই।
This matter and the plaintiffs, my lord.
Yes, 62, your application.
I'm for the petition. I'm praying for short passover, my
Yes,
lord.
62 is whose application?
GA 62.
Who is the applicant?
I am the applicant, my lord.
Okay, then not today.
Kindly short passover, my lord.
No Passover, no, not today.
Well, short passover, my lord. Short passover.
No, come on the next.
In this matter, I am clarifying one matter.
Yes, GS 62, let me take up.
My lord, in this matter, my lord, there was direction upon me to file an affidavit.
No, GS 62, you're for the applicant.
No, my lord, I'm not for the applicant.
Who is for the applicant? Whose application is this, GS 62?
My lord, the application is by a stranger, Sangeet Jairat, my lord.
Where is he?
He is not here.
Okay,
I
not
have not
today.
been served even.
So let him come, okay? Let's be taken up in his presence. Stop it.
My lord, I have been informed that he's coming, my lord, his clerk has come.
Anyway, so
No.
can't wait.
My lord.
25, not today.
Not today. 26.
My petition, my lord, it is that matter, my lord. Both Mr. Ghosh had
Told you if
Okay,
can
okay, yes. Not today,
My
just
lord,
not
one indulgence, my lord. If my lord sees my lord last order, my lord, it has been stated that the remuneration of the administrator has to be paid
come
from.
on the next day, okay? Just
Kindly records that my lord there is open for this issue of.
in the presence of all the parties, okay?
If my lord kindly passes an order to that extent because the
Just making it not today. It will be taken up on
one
next
thing, my
Tuesday.
lord, the administrator is asking us for payment from the.
Tuesday, it will be Tuesday taken up. Definitely.
That order can be passed.
Very well.
For item number 27, Lordship, I'm led by Mr. Shotaru Banerjee. I'm stuck in another court. Like, I'm trying for
This is my application, my lord. Mr. Thakkar is online. To connect করে দিন.
Okay, I'm making it not today.
I'm grateful.
My lord, I can start if your lordship permits.
Okay, let him come. I'll take it up in his presence.
Preliminary point so far as the
I'll take it up in his
maintainability.
presence. Okay, I'm just making it not today. Tuesday, I'll take it up.
Lordship.
Lordship, if I may permit it to mention a matter, Your Lordship, GA 26 and 25 of 2024 was,
Is it appearing in the list?
it is not, Your
So
Lordship.
what do you want?
If it can be kindly be kept before vacation any day, Your Lordship.
No, before vacation means when it is due to appear.
Today it was supposed to be supposed to appear.
Oh, it has not appeared.
It has not appeared.
Okay, it will appear.
I would have second. Your Lordship, any date if convenient for
In
you.
the usual course, it will appear.
It was fixed for 2 p.m., Your Lordship.
No, it will appear in the usual course. Thereafter, time will be fixed.
Grateful, Your Lordship.
Any other mention? We mentioned at number 28.
Yes.
Lord, may I find my
Let me see.
Copy, ma'am. Already copied.
Copy has been circulated.
Copy has handed to me. From the report, my lord, kindly see that entire building, 2 buildings, consisted of 2 buildings, entire building, mainly 58 Potuar Kala Lane, occupied by the trespassers. No rent is coming.
Yes, did you hold any discussion with the present receiver?
No, my lord.
No, my lord.
I think that was also there in the order.
Yes, my lord.
So unless you hold the discussion, you will not be able to know about the present financial position.
My lord, I didn't get the number of the present receiver.
No, you see, there is point number 4 also states that to hold discussion with the learned receiver appointed in this case and ascertain when rent was last collected. You see, point number 4 in page 13 of the order.
Yes, my lord. I have seen it. Hold discussion.
Because some said that they are paying to the receiver. Okay.
Yes, ma'am.
So you verify these things.
Then my lord, kindly.
Earlier, Mr.
Yes.
S.K. Chaudhary was
Anyway,
appointed.
you ascertain this position.
Thereafter, Prosun Ghosh was appointed.
You just give her the names. Learned advocate for the applicant and learned special officer are present. Learned special officer has submitted the report. Let it be kept with the record. It appears from the said report that the learned special officer has visited the two premises and at 21 Kanaithal Lane, Calcutta 7 lakh 12 and 58 capital B, Potuatola Lane, Calcutta 7 lakh 9. The learned special officer has also held discussions with the tenants of those properties and have also held discussions with the Shevites and have submitted the accounts, has submitted the report. However, it appears that in terms of order dated 6th August 2025, necessary discussion with the learned receiver who is appointed in this case was not held to assert thus the rent which was last collected could not be ascertained. Thus, the learned special officer is granted time to hold discussion with the receiver and to ascertain the rent which was last collected and the tenants who are paying rent and who are not paying the rent. Upon holding necessary discussion with the learned receiver, upon notice to the learned advocates for the parties, learned receiver shall submit report on or before 27/10/2025. Let this matter appear on 27/10/2025. The learned special officer is entitled to a further remuneration of 100 GMs.
My lord, one thing, my lord. My lord, kindly see the accounts. See the accounts. Already we have incurred much expenses towards DTs and others, and there are two parts. First year fees, my lord, I have paid.
Anyway, let us no, you are the applicant, okay? Your application was taken up for consideration. So that is why
true,
this is for a provisionally, you see, let us submit the accounts after holding discussion with the receiver, then necessary final order can be passed. Some needful can be done.
The fees, so far fees regarding the special.
Yes, it's a very nominal charge, not an exorbitant charge.
Twenty-nine and 30.
Well, we are glad that the matter has already been settled.
Page 29.
My lord, 29 is my learned friend's suit and 30 is mine. My lord, both the suits have been settled. It is only thing, my lord, may I kindly keep it on record, the communication from the bank.
Can I get a copy?
This is so far your client is concerned, that is the ICICI Bank.
Yes, my lord. Bank has already communicated me to take necessary steps.
So that is CS 772.
Yes, my lord.
Okay.
My lord, kindly allow us to come back with a proper terms of settlement so that on the basis thereof, we will the decree may be passed.
Yes, obtain the relevant documents.
Yes.
The resolution.
The resolution.
So that you do not suffer any type of allegations.
Yes,
like
yes, my
previous
lord,
case.
like the other suit.
Shall I keep it after vacation?
No. Kindly take it next
Yes,
week.
learned advocates for the parties are present. Learned advocates for the parties pressed for time to prepare the terms of settlement as the matter has been settled. Let this matter appear on 23/9/2025.
Terms of settlement হয়ে যাবে তো?
Yes, 23/9/2025 under the same heading.
Yes, yes.
Lord, both 29 and 30.
Both 20.
30 is my suit.
Both 29 and 30, same order.
My lord,
The communication to from the bank be kept on record.
File your terms of settlement. I'm just not passing any order. Because after you file the terms of settlement, entire thing will be over.
Very well. Good.
my lord, could it be 24th subject to your lordship's convenience? 23rd, there's some difficulty.
আচ্ছা ওটাকে 23 জায়গায় 24 করে
Deeply obliged.
Under the same heading.
Under the same heading.
Good.
31.
No, this is the application, my lord, for commission, my lord.
That is a suit. Lord commission today is the taken place. Lord commission lordship fixed it on next
No,
week.
what is the, which is the application to be taken up?
Lord, not application. Lord, it is a suit. Lord commission witness action is going on in commission.
Okay, okay. So some time is required.
Yes, Lord,
Today
today it will be closed. Lord, your
Today it will be closed.
Your lordship fixed it on day of next week. Lord, in the meantime, commissioner will file a report.
It will complete today. It will be concluded today.
Lord, we are cross-examining.
Oh, so you will conclude today. Today in the evening, that is.
Today. আমি তো বলবো আমি
Yes. Learned advocates for the parties are present.
I'm for the defendant.
You, who is for the defendant?
I'm for the defendant.
Okay, learned advocates for the parties are present. Learned advocate commissioner is also present. It is submitted by the learned advocate as well as by the learned commissioner that the
advocate for the plaintiff.
Yes, it is submitted by the learned advocates as well as by the learned commissioner that the evidence will be concluded today. Thus, this matter be listed on 15/9.
Not 15, not 15 is
Okay, okay. Let it be on
17. Lord, in the meantime, Lord, I
17,
think Lord, 17, Lord, commissioner will not cannot file report. Not on 17. Your lordship fixed it on 18th or so.
Okay, let
So
this
that
matter
by that
appear
time,
on
Lord, commissioner will file a report.
okay 22/9/2025. So the last remuneration paid was
Not remuneration as per your
was once
paid.
but
It is a full.
but 3 or 4 sittings have been held. Let a further remuneration of 200 GMs be paid to the learned commissioner.
My lord, may I mention?
No, it is shared by the
Yes, my lord.
parties.
Yes,
Yes.
My lord, earlier, my lord, may I be permitted to mention one matter? My lord, in the earlier occasion, when my lord was passed an order, the expenses and the remuneration of the commissioner was directed to borne by only defendant, my lord. It was not. It was.
No, remuneration was definitely by shared by the parties.
Yes,
Just now it is being shared, so this one is also to be shared.
It is expenses and the remuneration also. my
Not
lord.
expenses.
No.
Expenses at the
Expenses is just a formal expenses. This
No, my lord, there is huge expenses, my lord.
expenses at the
only I've said the remuneration.
Yes.
The remuneration will be shared.
Yes, yes.
And the expenses will be is also, my lord.
There
huge.
is no such order. The expenses
There was no such order, my lord.
expenses is upon the defendant.
Yes.
Only remuneration you share it.
Your Lordship,
Well,
the next matter was only with regards to filing written notes, my lord. Only that could be taken on record.
Which one?
The next matter, my lord, item number 30.
Item number 32.
I am for the decree holder. Written notes have been filed by me. A judgment debtor was required to file their written notes.
Which one? GA?
Lordship G5 of 2025.
GA5. That application I have filed for execution of mean profits, your lordship. The maintainability of that was challenged by the judgment debtor, my lord. That was heard after
Okay.
affidavit.
Record an order.
Lordship, the written note.
Learned advocates for the parties are present. The hearing of GA5 of 2025 is concluded. Let the written notes of arguments filed by the judgment debtor be kept with the record.
We had filed on the earlier occasion.
Okay. Let this matter appear on 24/9/2020.
Lordship, anytime after vacation, if the matter.
No, I'm fixing it for orders.
Lordship.
You have concluded your hearing. 24/9/2025 for orders.
Gratefully.
Much obliged, Lordship.
The next matters are also fixed for 4 orders only.
33
and
34,
34.
lordship.
33 and 34. You are for?
I'm for the plaintiff. Lord.
And I'm for the respondent in both the suits. It's their suit.
And my suit, but the application was the defendants. My application, sorry, GA4, substitution application.
GA4 in both the case suits.
Yes.
Yes, lordship.
Yes. GA4 of 2000. Yes, call these two now cases.
4 orders. Item number 33.
And 34.
34.
Yes. This application is allowed. Let there be an order in terms of prayer A, B, C, D, and E in terms of the master summons dated 10th day of June 2025. This order is subject to the payment of costs of 100 GM to the defendant and 100 GM to the State Legal Service Authority, West Bengal, within 1 week.
Deeply obliged, Lord. Deeply.
Yes. Call the next.
Grateful, your lordship.
Yes, this is with regard to this GA 67.
CS 67 and GA number 4.
No. 66 also this application was filed.
Yes, GA4,
In both the cases,
GA4,
is called 60, this next case.
34.
34.
Yes, this is also same order, but this 100 GMs is only to be paid to the defendant.
Defend. Deeply obliged.
Grateful, your lordship.
35 কি হবে?
To dispose.
My lord, for item 35 and 36, my lord. As per your lordship's order, my lord, the commissioner was appointed for taking the examination of the judgment debtor, my lord.
So come at 2:30.
2:30.
I have a division bench, come thereafter, 2:30. Yes, call the list.
Before your lordship takes up the fixed
Yes,
matter, my lord,
next to be mentioned.
your lordship has fixed matter 135 and 36 just before your lordship.
Yes.
Rising,
take-
my lord, I have mentioned the matter, my lord.
Yes.
My other side is also here. As per your lordship's last order, my lord, the commissioner was appointed for the purpose of undertaking the examination of
So
the
today is fixed for
judgment.
the report.
Yes,
was
it is.
for the report, but-
Yesterday, my lord, the examination has held at length, but could not be concluded, my lord. Your
So I have to extend the time to
time
submit.
has to be extended. My lord. They are supposed to produce some documents. We also required to do some homework
I'll
and
keep it
investigation.
after vacation.
After vacation, only thing is that, my lord, the witness judgment debtor has confessed that he is not under any advice of bed rest. And your lordship's court officials were also present. Your lordship can take a stock from them also. So he is absolutely fit and fine to be present before the court, honorable court.
Anyway, once
Now,
it
at
has
our,
commenced, let it be
the thing is that
concluded.
at our cost, my lord, he is enjoying the homely comfort. my lord.
Anyway, because it has commenced, let it be concluded. It
Let
will
it be
not take,
concluded, but it has not been concluded. Not
at
let
least
them,
it will take one more day.
1 or 2 dates will maybe required, my lord. Only thing, let them
Otherwise, you see, otherwise again there is some problem.
That
Again, it has to be
my lord,
deferred.
let them share the cost, my lord, because the cost is, my lord,
I shall consider on the next day.
deeply.
Yes.
Let the report be there. Based on the report, the advocate commissioner was supposed to ascertain the
Yes,
health.
learned
Based on that,
advocates for the parties are present. But up to this, the cost has been paid.
Paid by me only.
Learned
But they have to
advocate.
share.
No, actually, it is your witness. Okay, it is your application.
My lord, it was done by your lordship, not upon any application, my lord. It was done so motu.
Because in order to expedite the matter, I have.
Yes, sir, that is fine, my lord. But they cannot, my lord, enjoy the comfort only
Okay,
for
let
the
us let it be concluded. Learned advocate for the parties are present. Today was fixed for filing report by the learned commissioner as the deposition of DW.
This is only
Only one.
judgment debtor.
The
Judgment
Oh,
debtor.
as the deposition of the
Examination of
judgment
judgment
debtor is
debtor.
not yet complete. The matter stands adjourned till
2 weeks after vacation.
6/11/2025 for report of the learned commissioner. The examination shall be completed in the meantime.
And the cost aspect may be considered on the next.
On the next day, yes.
Next day. Grateful, your lord. Will your lordship record anything in this regard? Because I have an instruction to pay that, my lord. It
Yes,
will be
yes, on the next day makes up because some further remuneration is also to be paid.
may be required to
Yes,
pay,
so
but
at that
remuneration,
time
my
I
lord,
shall pass that order.
Yes. Deeply appreciated.
আর কিছু নেই তো আচ্ছা 2 PM fixed matter.
specially fixed matter at 2 p.m. Item number 1.
My lord, I'm appearing on behalf of the plaintiff. They are to commence the
Defendant, my lord, in this matter, my lord, since my witness was lastly done, so I will have to, I'm
Commence the-
supposed
So
to.
you are appearing for the first time.
Yes, my lord.
The argument is to commence.
Lord,
for the
actually, I
first-
was not well, my lord. Today also I'm not well, but my learned friend is being aggrieved for my absence, my lord. So I have come, my lord. I'll start at least today, my lord. And in the meantime, I lost my mother also, so I was.
Yes. I'm also seeing you after a long time.
Yes, my lord.
So probably you are appearing in the city court
Before your lordship, yes. Normally,
Yes. At that point of time.
Yes.
Yes. Okay, so let's take up the matter.
I'm starting it, my lord, but I'll not.
Yes.
My lord, basically, my lord, this is a matter. My plaintiff is my customer, my lord. I am bank. And I'm giving a picture, my lord, so that the matter comes. My lord, basically, I am a bank, my lord, and the plaintiff number 1 is a company who is my customer, and the others are my directors of the plaintiffs. My lord. They were having account with me, and ultimately they have filed this suit on few grounds. I'll just summarize those grounds, my lord. They have made some allegation against the bank that there was a premature encashment of a fixed deposit. Lordship, may kindly come to page number. Lordship is having plaint with your lordship.
No, this is additional in the plainter din to.
Page number 8 of the page. Eight. Amended plain बोला है। দেখি অরিজিনাল প্লেনটা অ্যামেন্ডেড প্লেন না না এটা না অ্যামেন্ডেড প্লেনটা চেক অনেকগুলো অ্যামেন্ডেড হয়েছে না এখানে প্লেনটে রয়েছে প্যারা 4 This is the plane. So no, I'm having a different plane. This is the plane, Indian Bank. This is the plane you saw. Para 4A is on page 8. It's not matching with this. When did we serve? This is I have not manufactured. Who did that? The amended plane একটা হয়েছে। এটাই তো amended. Amended. Green ink, blue ink, red ink, কত amended? এটাই তো amended. কত You have copy? Yeah, same way to. Amended half amended করা না। There's a problem. Amended, but we are not having. My lord, it's not matching with the copy. Page numbers are not matching. I am referring the paragraphs, my lord. Paragraphs because it is hand amended, but the copy which has been served to me is having a different pages. But the paragraphs are, my lord, perhaps same.
Yes, paragraphs.
Paragraph 4A, my lord.
4A, yes.
Yes, my lord. I've opened that page, my lord. So I think it's here in my it's showing as page number 8, my lord, but in lordship's copy it's showing page 2, perhaps.
Yes.
My lord, I'll be just reading that reference, my lord. In or about November 1999, the first plaintiff deposited a sum of rupees 80 lakhs with the defendant bank, purpose of investing and sum in the form of fixed deposit with the defendant. The said sum of 80 lakhs was duly received by the defendant and the money was invested by the plaintiff in a form of fixed deposit for a period from such and such at the rate of such and such, and the deposit confirmation receipt of such and such was issued and a photostat copy that is to be marked, my lord. A photostat copy was handed over to the plaintiff by the defendant. So the question is, when a fixed deposit is made, my lord, the original fixed deposits are normally handed, but only a fixed deposit, a photostat copy of the fixed deposit was handed to the plaintiff. Why it was handed, my lord? Because this fixed deposit was kept as a security deposit with me. It's their own admission that the original security deposit was not given, and it was pledged for a facility which they have taken later on. So, my lord, that is a sort of admission, my lord, which they are saying that the original fixed deposit was never handed to them. So, this document which they are referring that it was prematurely encashed was due to the same was pledged and the account was slipped into NP and it was encashed on the date as per the banking norms. So this is one of the one limb of my submission, my lord. I will later on I'll just go through the depositions and refer the positions, my lord. I'm just making the pictures. What is the main contentions made in the plaint, my lord. Second conditions, my lord, they have also raised, my lord, that there was a term loan balance which was. No, that is I've said. I'm just laying out the. Yes, they have. I've My lord, there was a second claim, my lord, by them, my lord, that there was a bank guarantee which was not issued as per their instructions, my lord, and it was issued for 2 years, though though they have asked us to change that into 4 years validity.
No, this is 4B.
My lord, I'm just making a picture what is in their plaint, my lord. Then I'll come directly. My lord, just for your lordship's convenience, I'm making what are the claims which they have made, my lord, in a lump sum. So that, my lord, it's really I'll argue it on later up by showing the appropriate paragraphs. My lord, I'm not having all the exhibits copy also, so I'm sorry for that. So I'll not be concluding today. My lord, there was one more contentions. I'll come through that. There was a claim for non-release of 25 lakhs of term loan, my lord. There was a prayer from them said that I should give a facility of 25 lakhs rupees term loan, which was their allegation is that we did not do. And one more contention was that they have exported some documents to Colombia, and we have not released the documents. For that, they have suffered some loss. So this is the main contention which they have made out in the plaint, my lord. Now I'll come each on each allegations, my lord. First contention of premature encashment of the fixed deposit. My lord, in entire depositions, my lord, they have never denied that it was not pledged with the bank. I'll come to the appropriate questions and answer, my lord, later on. And they have protested that it was encashed earlier, but they have never opposed that it was not pledged with the bank. And just a second. Exhibit 7 7 No, I don't think. Well, my documents are not arranged, so I'm
It's better you come with a compilation.
My lord, I'll keep it after vacation sometime, my lord.
Yes, I'm keeping it after vacation. You come with your
My lord, otherwise, my lord, I'm still
come with a compilation and list of dates.
Yes, my lord, I'll do so, my lord. Because my lord, all the documents are not ready with me. I'm sorry
record
for
and
that.
Learned advocates for the parties are present. Learned advocate for the defendant commences his arguments but could not conclude the same. Let this matter appear on 29/10. 29/10.
10 October
2025 for arguments.
Well, kindly fix the time if my lord.
My lord, the 29th, my lord, my learned friend will not be available. My lord. She's assisting me. So, kabe bolo? 20? Any day after that, my lord.
Okay, 3/11/2025 at 2 p.m.
My lord.
Oh,
that day
come
I'll
with the
complete.
compilation
I'll-
and list
not
of
that day
dates.
I'll also give a written notes of argument.
Yes.
Grateful.
3:11 হ্যাঁ আজকে আছে হ্যাঁ ডেকে দিন না 2:45 তো ও হ্যাঁ হ্যাঁ 2:03 হ্যাঁ ডেকে দিন আগে 2 PM তারপর 2:45
Item number 3,
My lord, I am appearing for the plaintiff, my lord. But on
No,
the
the
last
defendant.
occasion, my lord, the lordship, no, I'm not saying that.
You're not saying
No,
Very well.
on the last occasion, my lord, Mr. Auric Banerjee was submitting with regard to the definition of malicious prosecution. My lord. With regard to this particular fact, my lord, this malicious proceeding which they have initiated, on that basis, my lord, we have filed this suit. As a matter of fact, my lord, the lordship kindly takes up page 170 to 172 of Judge's Brief of Documents. Well, they have initiated this proceeding, my lord. They have initiated this proceeding, my lord, before the Rohini Court, Delhi, maliciously. My lord, there's a talks of settlement which is going on since 5/8/2003, my lord, and that is evident from the page number, my lord, page number 170 to 172, the letter which I am going to place. If your lordship may kindly have a look at this particular letter, my lord.
So this is
5th
marked
August-
exhibit. This
This
is
is marked exhibit.
okay 5/8/2003.
5/8/2003.
And when was the complaint filed?
Complaint was filed, my lord, on 10th November 2003. I'll tell you the sequence, my lord. Then it'll be easier for your lordship to understand, my lord, how they have come up with this particular proceeding and they have maliciously initiated that particular proceeding, my lord. My lord, this is the foundation stone of the settlement. 5th August 2003. If your lordship may kindly have a look at the reference, my lord, to discussion with Mr. Iman Nundi of Ozone Ayurvedics at our office today to settle the outstanding issue following claims which were not settled under details. Now, if your lordship may kindly takes up the next page, page 171, part of this document. These are the details, my lord, which they have agreed to settle on. And page number 172, which is very much important, my lord. If your lordship may kindly have a look at the top of the page, my lord, there is figure 88,543. Page 172 of the Judge's Brief of Documents. Did your lordship get it? Is a figure of 88,543. Now, initially, they have arrived to a settlement that we are liable.
This is your letter. This is letter from your
This
side.
is your letter, and they have
And two
accepted.
checks which were post
Yes,
dated.
yes, yes, and they have accepted it. And Iman Nandi has accepted on behalf of Ozone Ayurvedics, the defendant. Now, if your lordship may kindly have a look at the date, 5/8/2003, and the signature of Mr. Iman Nandi. Now, it was agreed, my lord, that two checks, which they are saying that we have given to them, we have certainly given to them, but the talks of settlement was going on. Two checks which are post dated, but can be arranged to make pay orders against the two checks before the presentation. This is important, madam. But can be arranged to make pay orders against the two checks before the presentation.
So check amounting to how much?
Amounting to 50,000 one
So
check.
where is okay 50,000.
50,000 another check.
88,000 or 38.
88,543. 50,000 one check, another check is 30,543.
So the instant complaint case is with regard to dishonor of two checks or only
Dishonor of two checks.
two checks.
checks.
One
Two
complaint with regard to two checks.
Yes, two checks. If your lordship may see, my lord, if your lordship may kindly takes up the list of documents. Page 7 and page 9.
If your lordship kindly takes up the list of documents, my lord, which they have handed over to us on the last occasion.
Page 7.
Page 7 of the list of documents which they have handed over. Not the judge's brief, my lord, the list of documents which they have handed over and relied upon. List of documents.
Last day जब मेरा आदमी कुछ तो तभी देर से
हम तो थोड़ा इवेंट में पहले आईपैड लिया
Man, may I
kindly refers my complaint.
Yes, page 7.
Page 7. One check which is post dated, my lord, 24th August 2003, page 7, amounting to rupees 50,000. And did your lordship get me?
Yes.
Another check, my lord, is at page 9. Amounting to rupees 38,543, my lord.
Yes.
It's 8 September 2003. My lord, after this, my lord, talks of settlement was going on.
What was the ground of dishonor? Non-availability of fund.
No, stop payment. Stop payment. That I have deposed. My witness has deposed in the cross-examination as well. If your lordship may kindly takes up the plaintiff witness cross-examination, my lord. Question number 93. Which they have, my lord, if your lordship may kindly takes up the deposition, my of plaintiff witness cross-examination. Cross-examination. এটা দুজনই রিলাই করছে এক্সিবিট তুমি ডিপোজিশনটা দাও, ডিপোজিশনটা প্লেন্টিভ উইটনেস ক্রস প্লেন্টিভের ক্রসের ডিপোজিশনটা দাও। Your lordship may kindly have a look at it, my lord. The deposition. No, ওটা ওদের। If your lordship may, I'm just reading it out, my lord. The question which is put forward to my client and the answer. Copy আছে? Thank you.
Present.
I'm just reading out the question. It will be easier for your lordship to understand. Then the documents will be placed before lordship. So the question which is put forward, my lord, before my witness by the other side. Would you agree with me if I suggest that instruction for stopping payment was indicated by you? Yes, as the this is the answer. Yes, as the settlement was already done. After informing the company and the bank, the payment was stopped and my payment was also done after the settlement. So, as a result, my lord, since the talks of settlement was going on, so the question of presentation of those
Regarding, you see, regarding settlements are definitely, okay, held. Settlement meetings are held but the matter is settled after payment of the amount. So did you file any documents before
Yes,
the
yes,
court
your lordship.
showing that you have paid these amounts?
Yes, I have paid 2 demand drafts.
No. Question is, at the time of presentation of the check, okay, definitely when you are forwarding this check, you must have stated that this amount is paid in
Yes.
terms of settlement of so and so.
Yes. Now, with regard to this terms of settlement, what I tell you, why I made this submission, this is the foundation stone of the settlement. Why I said that? But the only thing is that
Whether your terms of settlement was clear and specific
yes,
or not.
thereafter there was
Because
another.
there was no written terms
This,
of settlement.
this particular settlement was carried on. There was a meeting. I'll show it to your lordship from documents. There was a meeting in PLSA in Malad. This amount was again reduced. Again, there was a new settlement, and that has happened on 14th November 2003, Malad.
That means after the check was presented and
Yes.
dishonored.
No, after the check was not presented dishonored. It was the fact, Malad, that 2 checks which are post-dated, but we shall arrange to make pay orders against the 2 checks before the presentation. So they should, since the talks of settlement was going on at that particular point of time, so the question of presentation of checks, both parties have agreed, Malad, that we will not present it. But unfortunately, Malad, the defendants have presented those 2 checks. Now, thereafter, there was talks of settlement since it was going on, Malad.
After you received this notice, did you submit any?
This is my letter.
So this notice under 138. So did you reply to this
I
notice?
said that I haven't received any notice. I said, now, if your lordship may kindly give me some time, Malad, so that I can actually give a lordship a correct picture of this thing. Malad, after this, Malad, there was another discussion which was held in Peerless Inn between the parties. That is in the record. And on that basis, Malad, they have agreed to reduce this particular amount to 50,000 koto? 50,000 odd rupees. And if your lordship may kindly comes up to page 105.
So in the meeting, there was some minutes, okay.
Yes.
So did you exhibit those minutes of the meeting?
Malad, since it was not an official meeting, it's a meeting. It was actually conducted
So
by
that
both
is
the
an
parties.
understanding, whether
If your lordship may kindly comes to page number 105 of the list of documents, Malad, once.
You see, there is the ground to get exonerated in a criminal proceedings, that is one thing, okay. And ground to claim damages, that is another thing.
That is different. I'm not into this damages anymore. What I'm into is
This is for damages, definitely,
But
for
yes,
defamation.
yes.
A malicious prosecution.
What I'm harping upon is, Malad, this malicious proceeding is existing in this particular case. Now, if your lordship may kindly comes to page number 105 of the list of documents. This is Malad, it's a fixed matter in court number 37, Malad.
Okay, you come, it's better on the next day if you come with a compilation. Compilation and the list of dates.
Compilation.
I'm keeping it after vacation.
But my learned friend will.
Yes.
Till my senior comes.
No, you see, it would be easier if you come with a compilation.
The compilation is already before my lord in the form of list of documents and judge's brief. There is no other compilation which is required to be filed.
List of documents is
Yes.
there.
Yes. That are the documents which both parties are relying on. Me and them both. There's nothing else which is required to be filed.
All the documents are there on the record, as I feel.
that they
Malad.
can
It's just that it needs to be arranged in a proper manner.
Yes, learned advocate for the plaintiff submits, but could not conclude the submissions. Let this matter appear on 27/10/2025 at 2 p.m.
27. Oh, Malad, kindly keeps it in the month of November. My learned junior friend is.
Never get it.
Don't make fun, Mr.
4/11/2025 at 2 p.m.
411.
তোর বিড়লা আছে অন্য কারোর বিড়লা নেই।
না ঠিক আছে
এগুলোকে একটু ওই কম্পাইলেশন গুলোকে একটু গুছিয়ে ইয়ে করে দেবে।
One matter was fixed for 245. Original size matter. Item number 2.
Item number 2, it was fixed for what purpose?
That is affidavit of balance by the department. That is I have complied all the orders. That is the citation has been made. Then the affidavit of compliance, the original copy, your lordship directed to send the original copy of the by the department. Only to issue the
No,
certificate.
this report has been submitted. Okay, filing paper. অরিজিনাল এগুলো সব পুট আপ হয়েছে, অরিজিনাল পেপার পাবলিকেশন। আচ্ছা, তাহলে এটা রেকর্ড অ্যান্ড অর্ডার প্লিজ।
That was the order by my lord. Last occasion.
Learned advocate for the petitioner is present. Let the original copy, original of the paper publication be put up on the next date fixed. Let this matter appear on
Before vacation, madam.
24/9/2025.
Madam. But time.
In the usual course, it will be taken up.
Madam. At top.
Whatever, it will remain in the list.
Madam.
May the remaining matters may retain his position in the list.
Yes. Yes, call the appellate side matters.
Yeah, my lord, I want to mention an urgent matter. We just applied for this criminal revision for framing of charges.
Which matter you want to mention?
This is item number 74 of the daily list.
Yes.
Framing of charges is fixed on 19/9/2025 in the lower court below. The defense want to exhibit some extra documents, wants to submit some extra document, which is clear violation of the apex court judgment. So they relied on certain document during the framing of charges. 19/9/2025.
Okay, let us wait till next week. If it is not taken up, you mentioned it will be fixed.
Well, it fixed any day before 19.
No, I said, let us see till Monday. If by Monday, if it is not taken up, definitely.
Okay, man.
On Tuesday or Wednesday, it will be fixed.
Okay, man.
Lordship, under compelling circumstance, may I be permitted to mention one matter, item 144, your lordship. The next date before the learned trial court is on 15th, your lordship. That's why I am mentioning this matter.
What?
The next date fixed before the learned
Item
trial
number?
court, 144.
144. Yes.
Lordship,
Trial
then-
court regarding what?
Lordship, it's a prayer for, I have come up for quashing of the proceeding. Lordship, on that day, the,
Yes, which section?
Lordship, it's 498A.
Only 498A?
498A and 406.
Yes, let this matter appear. Huh? No, no. It is the date fixed is what?
15th, Lordship.
তাহলে কালকে করে দিন as a specially fixed matter. To be mentioned, to be mentioned.
Lordship, I am grateful. Deeply obliged.
Item number 1. The statement.
Correction. Wrongly applied, my lord.
Let me see.
09, my lord. Instead of 107, my lord. The 107 is one of the PS case.
GR case number 107.
GR case number 2049. 2009.
Haldia police station case number 107.
Haldia case number 107.
Instead of GR 107.
Okay, it should be GR case number 30.
2409
এখানে ইন্ডিকেট করুন জিআর কেসটা।
Yes, record an order. Learned advocate for the petitioner is present.
2409.
Matter is put up for necessary correction. In the last paragraph of the order dated 2/9/2025, instead of GR case number 107 of 2023, it should be GR case number 2409 of 2023. Stop. Let necessary correction be made.
In first paragraph also written the GR case number 107.
Similarly,
First paragraph.
in the first paragraph, instead of GR case number 107 of 2023, it should be GR case number 2409 of 2023.
Deep Lord.
Other contents of the order remain unaltered.
Kindly online added, case that is required, madam.
Yes?
Case that is required, madam. Case
Okay.
that is required.
No, that is not there in the previous order.
Oh, not.
That is not there.
Only the correction is unit. Deep Lordship.
Wait. Number.
May please watch. My lord, in this particular case, a very interesting facts, my lord, before I take your lordship to the point of law. My lord, the petitioner before your lordship, he's a doctor. Now, my lord, with regard to a plot of land which is situated within the jurisdiction of Durgapur police station, my lord, so at that point of time, the SBI, State Bank of India, he held an auction, and pursuant to that auction, he purchased the said land. The petitioner before your lordship. Now, my lord, this land was taken over from another company called SR Worth, which had defaulted in its loan, and as the land was mortgaged to SBI, so therefore an auction was held and the petitioner purchased it. The opposite party number 2, my lord, he is a land mafia. Now, based on this action of being a land mafia, he has done several hindrances with regard to the petitioner taking over the peaceful possession of the property. Now, my lord, there were writs which were pending, and we have got favorable orders, but I will not trouble your lordships with that. Now, my lord, coming to the
De facto complaint is?
He's a land mafia. He's the opposite party number 2. He's
the de facto complaint.
He's the de facto complaint.
Well, let me see the complaint, please.
Now, your lordship may kindly see the last page. I've challenged a 107 proceeding, my lord. Now coming to the point of law, lordship may kindly see the last page. Last page once. Lordship may see the date of the order 13th of May 2025, where, my lord, at the bottom of my, it's a typical type order, with deepest of respect to the learned magistrate, lordship sees the sections which have been invoked 107 and 116 of the Code of Criminal Procedure. But by that time, this statute has been repealed and BNSS has come into force from the 1st of August 2024. And yet, my lord, in a pre-formatted, pre-typed order, my lord, this is being passed. My lord, I would take your lordship.
Regarding merits, what do you have to submit?
My lord, this is with regard to the point of law, my lord. Now, with regard to the merits, your lordship kindly takes up page number 130 first, my lord. And prior to that, page number 71, if your lordship may kindly take some, once. Page number 71. Page number 71, my lord, I had preferred a writ application. Pursuant to which, my lord, it was assured that the police would take necessary steps so that these kinds of land mafia or these kinds of unauthorized obstruction is not done, since I'm a bona fide purchaser. I have purchased it from the bank by way of an online auction. Now, on the basis of that, I should not be troubled from enjoying my peaceful possession of the land. As well as page number 130. These are the two orders. Writ petitions are pending with regard to the purchase of the land. Rather, what the opposite party number 2 does to ensure that I am ousted from the property, he takes out a 107 proceedings.
Okay, let me see the complaint before the.
My lord, the last page, if your lordship kindly sees, by way of a PR, your lordship kindly sees the last page.
Yes. So this order was passed upon inquiry. So
Prior order, no, my lord. This order was not passed upon inquiry. Police received a complaint and made an inquiry and then prayed before the learned magistrate to issue an order under 107, so-called 107. Your lordship may kindly sees. The date is 27th of February 2025. Incident is dated January. He lodges the complaint in February. Order is passed in May, 13th of May 2025.
So how did you acquire this land?
It is my own land. I have purchased it. It is my own land. Then rather, my lord, I have annexed everything. It is my own land. The State Bank of India held an auction. I was the highest bidder. I paid money and I've taken the land. Now, these are the land mafias. The lordship can understand how they are operating in the premises.
Now, this is where is the complaint of the police authorities?
Well, that is the very last page, my lord, of my petition. That is the only complaint, my lord, which is there.
This is the only complaint.
Yes, my lord. That is the only complaint. Lordship sees the date. I'm placing it, my lord. On 8th of January 2025 at about 8:30 p.m. OP members as noted in column number 3 with
Where
some
is
men.
that order? Any directions upon you?
Yes, my lord, the previous page. Lordship may kindly sees. It's a pre-formatted order. Seen the police report of Faridapur IC, NCR number so-and-so dated 27/2/2025, which is stated that
The
Ashok
last
Bharti.
page, okay. The certified copy is the last page.
Yes, yes.
Okay. Now, which page? That is page?
My lord, no, my lord, this is the certified copy only I'm relying upon.
No, certified copy is the last page. Okay.
My lord, your lordship has the page, my lord, where the order has been passed on 13th of May. My lord, this is the page.
No, this order is of 13th of May.
Yes, my lord, bottom part, your lordship will see. Is are creating disturbance, praise for drawing up proceedings accordingly, I fill in the blank order.
13th of May.
Total fill in the blank order, my lord. My lord, your lordships have, my lord, deprecated this, but with deepest of respect to the learned court below, my lord, but your lordships have deprecated this fill in the blank order. Lordships have deprecated the fact that if CRPC has now been repealed, then proper provisions of law of the BNSS ought to be invoked now. And since the entire cause of action arises post the BNSS being repealed, my lord, then such kind of manner in which, my lord, a person has been subjected to these proceedings, my lord, is uncalled for, my lord. Especially the petitioner being a doctor, a bona fide purchaser, he has all along acted within the confines of law.
Yes. When is the next date fixed?
My lord, 15th of November.
Yes. So till today, did you appear before the magistrate?
Yes, I've appeared before the London magistrate. I've appeared before the London magistrate, my lord. That is how I've obtained the order copies, my lord. I have made appearance.
Appeared, and what was the last order passed? This is the.
No, this is the
3/6/2025. What is the?
My lord, on 3/6/2025, I have just entered appearance. No further orders have been passed. This is the only order, my lord, which has been passed in the connection with the present case. And I'm aggrieved, my lord, by this order, my lord, since I'm a doctor and this person is being subjected to this kind of harassive proceedings, my lord, especially when a writ is pending, my lord, before this Honorable High Court. I'm praying for a stay of this order, my lord, proceedings. My lord, deepest of respect, my lord, this order is bad in law, bad on facts, my lord, and more so, my lord, no subjective satisfaction has been recorded.
This is a show cause notice. No final order is passed, nor any condition.
My lord, I am aggrieved by the fact in the manner in which 107 proceedings have been invoked against me. My lord, this order is the starting point of the 107 proceedings. Final order, my lord, would be subject, with your lordship, my lord, is far more experienced than I am, but final order would only be passed after inquiry under 116 subclause 3 is being done. My lord, I would be aggrieved by that inquiry also. I am aggrieved by the manner in which 107 has been initiated against me.
Question is, you see, these order was passed when there is a suppression of different material facts.
Yes.
So unless these facts are brought before the executive magistrate, how can you say that the executive magistrate did not apply the
My lord, today, my lord, I would, my lord, leaving aside the factual background, leaving aside the
question is, you see,
lordship may seize the order.
not a question of any trial of any offense, okay?
This would be an inquiry. This would be an inquiry as per
question is, many facts which ought to have been placed before the magistrate is not yet placed, okay? Now the question is, unless the facts were before the magistrate and the magistrate did not apply the mind to the facts and have come to a findings, you could have said that this is a.
My lord, just, my lord, in response to that.
When there is a suppression of material
My lord,
facts that can.
my lord, I'm letting aside the suppression factor, my lord. My lord, today, my lord, I'm dealing with the order on the face of it. My lord, may kindly seize the order. My lord, where is, my lord, the requirement of the Honorable Apex Court, my lord, since Madhulima and all the subsequent judgments, my lord, is very simple, that there has to be a subjective satisfaction with regard to the facts of the case, that 107 proceedings ought to be drawn up. My lord, today, where is that subjective satisfaction? In the order, my lord, which is there. Lordship, may kindly seize. My lord, where is the application of mind? My lord, with deepest of respect. My lord, where is the application of mind? My lord, even words are not even struck off. Your lordship, if I can just place out the order, it's merely a blank formatted order in which certain handwritings have been given to fill it. Even Rule 183 of the Criminal Code Subordinate Rules, my lord, even that mandates that an order has to be either typed or handwritten. These fill-in-the-blank orders have been deprecated, my lord, all throughout. Lordship, can you see where is the subjective satisfaction to the factual backdrop of the case? Whatever it is.
I'm having regard to the materials on record.
My lord, lordship sees the line before that. Is are creating disturbance and praise for drawing up a proceeding under 107, 100 section 16 subclause C against him, them. Having regard to the material on record, I am of the opinion there is ground to exist. This is a pre-typed order. OPs is are hereby directed to appear before this court and file show cause on so and so. Why he, they. Should not, my lord, is this, my lord, with deepest of respect, this is a judicial order, my lord. Can this order, my lord, in this form even exist? My lord, especially, my lord, in light of the law which is laid down. It would, my lord, be an abuse, my lord, to carry on, my lord, in this way. Or I would rather beseech your lordship, my lord, to set aside this order. If the complainant is aggrieved by anything, he can file a fresh 107 proceedings, and the learned magistrate would apply his mind and then pass an order, my lord. This kind of orders, if it is allowed to sustain, my lord, it becomes, my lord, a dangerous precedent, my lord, because these orders, these pre-typed, pre-formatted orders have been deprecated time and again by the Honorable Apex Court.
Actually, on the basis of this complaint,
just
issued the notice. Okay.
My lord, order has been passed.
Proceedings was initiated. Okay.
Yes.
So where is the illegality?
My lord, illegality, my lord, I'm telling your lordship. My lord, I'm telling your lordship.
Yes,
Kindly have the code of criminal procedure, my lord. Your lordship, kindly have that. আমাকে একটা copy. Yes. Lordship, kindly sees 107 subclause 1.
Yes.
Yeah, this is the CRPC name. CRPC name. CRPC. Yes. नहीं तो ना खुले तो Lordship, if I can place, my lord, 107 subclause 1, my lord. If I can place it.
Yes.
When an executive magistrate receives information that any person is likely to commit a breach of peace or disturb the public tranquility or to do any wrongful act that may probably occasion a breach of peace or disturb public tranquility and is of the opinion there is sufficient ground for proceeding. Lordship marks that he may, but this is a discretionary power, my lord. This use of the word may gives a discretionary power upon the special magistrate to decide as to what cases 107 is to be invoked. In manner in which hereinafter provided, require a person to show cause as to why he should not be ordered to execute a bond for keeping a peace for such period exceeding more than 1 year as the magistrate may think fit. So, my lord, this discretionary power, as per my, my lord, limited understanding, is not in conformity to the law laid down by the Honorable Apex Court. It's not in conformity to the statute involved also.
Whereas, let us see the judgment of the Apex Court.
My lord, that I am not armed with right now, my lord. If your lordship can gives me, my lord, I can provide it. Your lordship can gives a short pass, I'll my lord, provide it before your lordship. Lordship can take it up in half an hour's time, my lord. I'll provide the judgment to your lordship. Madhulima.
Yes, short pass over.
Deprecate.
Book लेके आओ टा.
Number 3.
Well, this is also my matter, my lord.
Why in this matter we are having state.
Yes.
Madhurima judgment even or Supreme Court.
Supplementary affidavit. My lord has, my lord, item number 3-4.
Yes.
My lord, in this case, my lord, the petitioner before your lordship, my lord, he is the victim. Now, my lord, over here, my lord, they are running
petitioners.
Petitioners, my lord, they are victims of a scam, my lord, which has been undertaken by the accused person. Now, your lordship may kindly have page number 22 of my application.
Which for the accused persons?
My lord, we have served upon them. My lord, we are for the complainant. And my lord, as of now, we are aggrieved by the action, my lord, of the state, which is why we have approached your lordship's court, my lord. My lord, page number 22 is the 156.3 application. My lord, this club is a cricket club which runs as per the grant which has been given by the Cricket Association of Bengal. Now, my lord, the accused person, he is a treasurer of the Cricket Association of Bengal, as well as he is a secretary of the present club.
Okay, accused person.
Accused person.
Okay.
Now, my lord, the accused person, what he has been doing for vast some time now, has been taking out money from the Cricket Association of Bengal, which is a public money, and has been routing it to the club, and then taking out the money from the club and has been taking it into his own personal bank account. My lord, this is the manner in which the money is being circulated by the accused person. These are all on records.
Yes.
Based on that, my lord,
So on the basis of the allegations against this accused person,
yes, my lord.
That is petitioner number, that is opposite party number 2.
Yes, my lord.
This case was instituted.
Yes, my lord. Against the
and the investigation was taken up.
Investigation was taken up.
Yes.
Now, my lord, the investigation, it was directed that the Lake Police Station would undertake the investigation. Why it was directed, my lord? Number one, my lord, is that the bank account which is in question, it is within his jurisdiction, number one. And number two, the residence of the accused person is within the jurisdiction of Lake Police Station. Now, I'll tell your lordship, my lord, what I am aggrieved by and why we have approached your lordship's court. Now, my lord, without informing the complainant and without stating any proper grounds whatsoever, my lord, the Lake Police Station somehow, my lord, surreptitiously transfers the entire investigation from itself to Maidan Police Station. Merely because Cricket Association of Bengal is there. Lordship, may kindly have the order dated 14th of July 2025. That is the last page. My lord, if I can place the order, last page, my lord.
Order?
14th of July 2025 order.
Yes, yes, yes.
On this day, the IO has submitted a petition praying for passing of necessary order for transfer of this case to Maidan Police Station. Heard the learned public prosecutor who submitted in resonance to the prayer of the IO. Perused the case record as well as the case diary. It reveals that the prayer of the IO is ratified by the facts revealed in the case diary, and thus it is justified and needs to be hoisted license in order to secure probe for the prayer of the IO for transferring the case record from Lake Police Station to Maidan Police Station is allowed. GRO is directed to transfer the original case record to learned CJM Calcutta and maintain a part record with the copy of the order sheet. IO is directed to hand over the case diary to the OC Maidan Police Station with an intimation to this end. Now, my lord, it is at this stage, my lord, the case is in a flux. We have no knowledge what is going on with the case, number one. Number two, my lord, our predicament.
What is the error in this order?
My lord, the error in the order, my lord, is that which I can submit. I know it is.
Please,
sorry.
Error. Please show me the.
Yes, my lord.
Show the error.
My lord, I believe, my lord, I was thinking I was saying something amusing to my learned senior to the state. My lord, your lordship, my lord, the error in the order, my lord, is that today, when a learned court by way of a 156.3 application They had taken this point of maintainability at the stage of 156(3) application itself. In spite of that, the learned court directed the Lake Police Station to investigate the case. The bank account of the petitioner is within the jurisdiction of that police station. The accused person is within the jurisdiction of that police station. Now, my lord, there are certain extraneous factors, my lord, which I don't want to, my lord, reveal at this stage.
Now the question is, when in the 156(3) petition, that was filed when?
My lord, that was filed. Your lordship kindly takes up the 156(3) petition. Page number 22, your lordship kindly sees.
18 June.
18 June.
2025.
Supplementary affidavit. My lord, there's a supplementary affidavit also. If your lordship may kindly have that, my lord. It is with the case record itself.
Page 22.
Yes,
Yes. This was the petition under
Yes.
156(3).
On 18th of June, my lord, an order was passed, my lord, directing the Lake Police Station to conduct an investigation. My lord, that certified copy, my lord, is there in your lordship's bunch.
Yes, yes, yes. Eighteenth of June.
Yes, my lord.
There was a direction to treat this petition as an FIR and to investigate the matter.
Yes. That is one Lake Police Station. Now your lordship sees thereafter. The order dated 2nd of July 2025. Last paragraph.
Second of July 2025.
My lord has got it, my lord?
Second or 14?
My lord, second. 2nd of July, my lord. 2nd of July.
2nd of July order is not in the petition.
No, so certified.
No, there is no in the petition.
Which page?
My lord, this is certified copy, my lord. I'd hand it over. My lord,
Certified copy.
Yes, my lord, original, there's a separate certified copy bunch, my lord, which was handed over.
No. This is what I have with me is this.
My lord, that has my copy, my lord, once.
It is not in the petition, my lord.
It is not in there.
The petition they have served upon us, my lord. This is not in the petition. This order.
Give a copy to the.
That is in my case diary, my lord.
That is there.
Yes, yes.
I like to show this order, my lord, also.
Yes,
My
yes.
lord,
Let me
kindly
see.
see the order. See the order.
Okay.
Is there any preliminary inquiry or not? This is my learned friend's grievance, my lord. So they
No. That is not the grievance. My lord, if I can just, my lord, repeat my
just
kindly read this order. Kindly read this order.
2nd of July, my lord, 18th of June, my lord, first order was passed for preliminary inquiry by the Lake Police Station.
Yes.
Now your lordship sees the third paragraph, what they have stated.
Read, my lord, kindly read.
In inquiry report, it has been pointed out by the learned concerned officer PS that no cause of action had taken place under the jurisdiction of Lake Police Station. Same point. At the preliminary inquiry stage. And after considering everything, it was directed that the Lake Police Station would investigate.
No, earlier order was a direction upon the Lake Police Station.
To investigate. And now what they do, your lordship sees, my lord, 2nd of July order. 2nd of July, my lord, Lake Police Station took a point that they don't want to investigate because the cause of action, as per their understanding, is not within their jurisdiction. And in spite of this point taken before the learned magistrate, it was directed that the Lake Police Station would conduct an investigation. Then within 12 days, my lord, how could that impugned order be passed saying that, no, we don't have any jurisdiction, let it be transferred to Maidan Police Station?
So this is 2/7/2025.
Yes, 25.
Of the magistrate.
Yes. And the impugned order is 14 July 2025. Within 12 days, the investigating officer once again says that no, Lake Police Station has no jurisdiction to investigate. The learned magistrate with details has said that no, Lake Police Station has the jurisdiction to investigation. As per law,
my judgment. Yeah,
Okay, 7-8 was fixed for the report.
Yes. Now your lordship sees keeps the 2nd July order on one side. Lordship now sees 14 July order one side.
Yes, what do you say?
My lord, lordship has seen now.
Yes, yes.
This is the place where I am the complainant.
No. Question is, you see, on the basis of the some materials, the court has come to the conclusion. Let us consider.
Yes, what material? Deep.
Yes.
Deep regard.
My lord, in the 2nd of July order, the second paragraph, my lord, if lordship will kindly see. My lord, I am just reading. My lord, in the inquiry report, it has been pointed out by the concerned officer of Lake Police Station that no cause of action has been taken place under the jurisdiction of Lake PS. And earlier also on the point of jurisdiction to letter of complaint received from complainant such and such against Mr. such and such was sent to the officer in charge of Maidan Police Station. So this is for the first case, my lord, between the parties. Earlier occasion, my lord, 2 cases are pending. My lord, these are pending before Honorable Justice. My lord, kindly consider this report once. My lord, this order.
No. These are there are other case pending between the de facto complainant and the some of the accused persons.
Yes,
de facto complainant.
Same issue.
So they are being investigated by the
Maidan Police Station. So let my lord transfer this prayer made before the magistrate to transfer the case, because earlier 2 cases are pending before Maidan Police Station, to tag this matter also in Maidan Police Station. And my lord, in the question of jurisdiction, my lord, lordship is well aware of than us everyone, my lord, that now BNSS, my lord, introduced this GOFIR. That is, my lord, we can lodge anywhere any FIR if the cognizable offense has been occurred. This is 173 subsection 1. So, my lord, if this order, I fail to understand, my lord, how could my learned friend is prejudiced, where, my lord, these 2 cases already being investigated by Maidan Police Station, and this 3rd case, my lord, has been lodged before the Lake Police Station, and it has been transferred to Maidan Police Station to tag other 2 case, my lord. I fail to understand, my lord. And my lord, 2nd of July order, June order, my lord, is clear, my lord. Why this IO, after the preliminary inquiry, IO is satisfied, IO is submitting his report, and my lord, magistrate is satisfied with this report, and thereafter he transferred the entire document to the.
This 2/7/2025.
Yes, my lord.
This was the earlier report.
This is the preliminary, because my lord, 156(3), my lord, is mandate. There is a preliminary report must be done in BNSS.
So it was the direction it should continue.
Yes, my lord. And my lord, 2/7 order, my lord, the submission of the report, and 14/7 order, my lord, the IO asked for the transfer, and that has been allowed.
So what is that petition? Do you have that copy of the petition made by the IO?
My lord, yes, my lord. Yes, my lord. This IO. I have. Yes, my lord. That is it. My lord, I'm there. Actually, no, 100% আছে, থাকবে না কেন? My lord, I'm. But the photocopy of the case diary is the problem. Probably in the original case diary, the petition is there, but in the photocopy, my lord.
What is bothering
Then
me,
if
my
lord,
lord,
if lord will kindly direct me, I will produce the original case diary on the next day, my lord. Tomorrow.
Let it be not today.
Yes, my lord. Tomorrow.
My lord, not tomorrow, my lord. I will be out of station, my lord, from Friday to next Friday. My lord, if it could be kept on 22nd, my lord, and in the meantime, let them, my lord, file a progress of the investigation, because I am the complainant.
No, let me ascertain. I have to dispose your application.
Yeah, absolutely, my lord. My lord, then keeps it on 22nd.
Monday, no? Monday.
No, Monday is 15. Probably.
15.
My lord, I'm from this Friday, my lord, coming Friday, my lord, tomorrow to
Why
next.
This matter will be kept for pending for a long
My lord,
period?
I will be, my lord, out of station. That is, I could be requesting your lordship. Otherwise, my lord, my junior can do it if your lordship so wants. My lord.
Yes, I will only submit the case diary, my lord. Nothing to say, because my learned friend has argued at a length.
Submit what is the petition's file.
Yes,
What
that is all. That is
give
all.
that petition.
Okay.
Yes, record an order.
Tomorrow could be.
Let this matter appear on 22/9/2025 under the same heading.
My lord.
Deep regret, deep regret. Much grateful to your lordship. My lord, would indicate that they were to file applications in the order, my lord.
Yes, learned advocate for the state shall submit the relevant case diary in this regard.
Deep regret, deep regret.
Texting করবে। বড়টা পরিষ্কার করো।
Number 4, 5, 6, 7, 8, 9.
বোর্ডে 4 দেখাচ্ছে, বোর্ডে 4 দেখাচ্ছে।
এই বোর্ডটা ডিসপ্লে করছে না।
So here is item 4.
My lord, 6, my lord.
Yes, call item 6.
Item 6.
My lord, I'm for the petitioner, my lord. My lord, 6 and 7 are, my lord, similar matter, my lord. May I place the matter, my lord?
Yes, yes. So what is the order first?
My lord, if your lordship comes to the last page, my lord, what I'm aggrieved with, my lord, order is being passed, my lord, but there is a direction, my lord, that the amount of monetary relief shall be adjustable to any other monetary payable to the aggrieved party by the respondent previously awarded either in this case or in any other proceeding. Two applications were filed, my lord, under 125 CRPC and one is under 12 DV Act, my lord.
Yes.
My lord, there are separate orders. In
The
separate
question is, if you are entitled to a particular amount,
my lord,
okay, but you are receiving some other amount from some other order, so that has to be adjusted.
No, my lord, this order I clarification I had sought before the judicial magistrate, my lord.
Anyway, what is so ultimately?
Ultimately, my lord, in both the orders I have been granted 8,000, my lord, to the lady and to the daughter, my lord.
So according to you, the amount awarded is meager amount.
Meager amount, one point is it is meager amount, and second is, my lord, it restricts me to take the advantage of the other order, my lord, because it has been stated that if I have been awarded any award in other proceedings also, that will be adjustable.
That has to be decided. Anyway, record an order. Learned advocate for the petitioner is present. This application is directed against order dated judgment and order dated 25/8/2020. No, judgment and order dated 11/3/2025. This is an appealable order. So have you preferred an appeal against this order?
My lord, I have not preferred an appeal.
So you can an appeal has to be preferred against this. This is your case has been decided finally.
My lord, my case has been decided.
So you have to prefer an appeal. Anyway, I'm just making it not this week.
My lord, kindly direct, my lord, to the respondent number 6, my lord, at least to continue one of the.
Question is, you see, if it is an appealable order, how can this matter be filed here? Because you have to exhaust the remedy in appeal. Because you see, under the Code of Criminal Procedure, CRPC does into both under the old law as well as under the criminal procedure, that is civil.
Mobile.
Civil procedure, right? Yes, you have the Code of Criminal Procedure. My lord, I don't have it. May I come back, my lord? Just a minute. Just consider this. This is an appealable order. I am making it not this week, my lord. Huh? No, I'm just making not this. It will appear. মানে লিস্টে ওই দিন থাকবে, সোমবারে থাকবে. Let the matter appear on 15/9/2025 under the same heading. Grateful, my lord.
Seven, 8, 9.
My lord, I am appearing on behalf of the petitioner in item number 9. My lord, this is an application for expeditious disposal of an application filed by the aggrieved person under section 12 of Protection of Women from Domestic Violence. The case had been filed before the jurisdictional magistrate on 16th of January 2023, my lord. And since then, there has been multiple adjournment that has been given by the trial court. And till date, the interim hearing has not been conducted.
Yes. Learned advocate for the petitioner is present. This application is made with a prayer for direction upon the Learned Judicial Magistrate 9th Court at Alipur, South 24 Parganas, to dispose of the proceedings being AC 134 of 2023 expeditiously. It appears that the said proceedings was instituted in the year 2023 and is pending till today. Upon perusing the petition, this court is of the view that no fruitful purpose will be served by directing service of notice upon the opposite parties. Thus, this application is disposed with a request upon the Learned Judicial Magistrate 9th Court at Alipur, South 24 Parganas, to dispose of the said proceedings within a period of 4 months from the next date fixed.
Much obliged.
Your lordship, I'm praying for not today.
Okay, not today.
Item 11.
Make pleasure. But the petitioner is assailing the filing of the charge sheet, taking cognizance of the offence, commitment of the case to the court of session, and the taking cognizance of the offence by the court of session. This case under 399, 401 of the Indian Code.
399, 402.
401.
401, it's stated.
I'm sorry, 402, I extend correct.
That is attempt to, that is.
But the complainant is an ASI of Branda police station. He had prior information that some person will assemble near a local bridge for the purpose of committing dacoity. He had been to that place along with other police personnel. At the sight of the police personnel, 4 of them fled away and 3 of them were arrested and they were taken into custody. So, but the petitioner is concerned, there is nothing whatsoever in the charge sheet. Nothing.
Question is, was he arrested or he surrendered?
Arrested and he is released on bail.
He was arrested. Was there any recovery from him?
No, nothing whatsoever. Nothing.
Page 12, where you ordered a bill order, nothing was recovered.
And return to blood, page 12.
Page 12.
Order dated 21st of January 2023.
Order dated 21st of January 2023.
Page 12 of this your petition.
My petition. 12 no, sir.
It is certified copy.
Of the certified copy. But the order dated
21st of January.
21st of January 2023.
Nothing is there is no report.
It appears.
No prayer for TI period has removed. I did not pray for miscellaneous of this.
Got that?
Yes, 21st, 2023. Yes, here is put up at the prayer of the
This
learned.
clearly will not explain the substance of the case on which the petitioner is pleading here.
So we were produced on that date. So after the charge sheet was submitted, you were produced on that date.
That day, nothing recovered from the petitioner that is recorded by the learned.
Let me see that order.
Is it 21st of January 2023?
Yes, yes.
I have never prayed for PC. No TI period. But there was no deputy.
No local witness, nothing of the sort. All are police personnel. All the witnesses.
And he was not named in the FIR.
No, nothing.
Yes. Record an order. Mr. Bashu, learned advocate for learned counsel for the petitioner, is present. Mr. Basu submits that the petitioner in this case is falsely implicated, and although there was no recovery from the petitioner and nor he was named in the FIR and no materials against him, but he has been implicated and charge sheeted. Learned counsel draws attention to the order of the learned Chief Judicial Magistrate, Purbo Bardhaman, dated 21/1/2023, wherein it is observed that the present petitioner was not named in the FIR, neither there was any recovery from his possession, and nor any prayer for TI period been made by the IO. It is submitted further that all the witnesses are police persons and there is no independent witness to corroborate the case. Upon perusing the petition and the materials on record, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings in here case number in GR number 6495 of 2022, arising out of Raina Police Station case number 504 of 2022, dated 17/12/2022, pending before learned Chief Judicial Magistrate at Purbo Bardhaman, and thereafter committed to the Court of Sessions, Purbo Bardhaman.
In the Court of Session, not the Description of the case is Sessions Case number 2 of 2023.
Okay,
2025.
being Sessions case number,
I'm giving a lordship the copy.
okay, being Sessions case number 2 of 2025 for a period of 3 weeks after Puja vacation.
Grateful, Your Lordship. Let this copy be kept to the record, the certified copy.
Let this certified copy of the order dated 19/6/2025 passed by the learned Sessions Judge Purbo Bardhaman be kept with the record.
Grateful, Your Lordship.
Item 12, my lord, I appear on behalf of the petitioner.
Yes.
This is an application for expeditious disposal of a matter. Lord, the FIR was registered in 2012. Charge sheet was filed in 2013. Charges were
You are
for the petitioner, my
for
lord.
the petitioners are the accused persons.
No, my lord, the de facto complainant. My lord, I am the prosecution witness 1. My lord, my examination chief started back in 2014. My lord, 11 years, my lord, till now, my lord, my examination is in chief has not been
You are the de
concluded.
facto complainant.
My lord.
Where is the order sheet? Let me see.
My lord. My lord, and if your lordship kindly takes up para 3 at page 4, my lord, I have prepared a list of dates, my lord, in
para 3, page 4.
Page 4, my lord. This is a gist of all the orders passed. About, my lord, almost 59 occasions.
Yes.
Till now, my lord,
It was under which sections?
But this is 420, 406, my lord, of the old code.
How many prosecution witnesses have been examined?
My lord, not even one. I am the PW1. My examination in chief is still continuing.
Okay. How many witnesses are there total?
My lord, about 6.
6 witnesses. When is the next date fixed?
My lord, 6 witnesses, and my lord, the next date is, if your lordship kindly gives me, it was on 19th of August, my lord. I'll just have to take instructions, my lord. The last date was on 19th of August, my lord. But even on that day, my lord, my examination was not completed.
Yes, record an order. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. The petitioner in the instant case is the de facto complainant of Narkeltanga PS case number 125 dated April 12, 2012. Now pending before the Court of Learned Judicial Magistrate, Second Court at Shialda. Stop. It is the contention of the petitioner that although the case was instituted on 12/4/2012 and charge sheet submitted on 8/5/2013 and charges framed on 21/1/2014, but till today the examination of the de facto complainant is not over. Learned advocate for the petitioner submits that several dates the matter appeared, but till today the examination of the de facto complainant could not be completed. In the facts and circumstances, this court is of the view that no fruitful purpose will be served by keeping this matter pending and directing service of notice. Thus, this application is disposed with a request upon learned Chief Learned
My lord, Judicial Magistrate, Second Court.
Learned Judicial Magistrate, Second Court. No, okay, now. So now pending before Court of Learned Additional Chief Judicial Magistrate probably.
My lord, it was filed, my lord. Thereafter, it was transferred to
okay, pending before. But your prayer is this ACJM.
My lord, I might have made a mistake, my lord. In that case, it was my error, my lord. If I may have leave to correct the prayer.
Okay. now pending before learned judicial magistrate. Acha. This matter is disposed by requesting the learned judicial magistrate second court at Shialda to dispose GR number 1062 of 2012 expeditiously and preferably within a period of 6 months from the next date fixed. Liberty is granted to the petitioner to make necessary correction in the prayer.
I'm grateful, man.
In item number 13, Lordship, I beg to appeal on behalf of the petitioner virtually, Lordship. I am praying for short passover, Lordship. I am in the court, Lordship. I will be there. Kindly make a short passover, my dear. Allow short passover.
Yes.
I will be present, Lordship. I will argue in this matter, Lordship.
Item number 2. My lord, which your lordship was here.
Item 13, not today.
My lord, item number 2, my lord.
Okay, item 2.
Yes, my lord.
13, not today.
My lord, I was referring to the judgment, my lord, of Madhulimai. If your lordship, my lord, may kindly have my tab, my lord. Paragraphs 33, 35, 36 and 37. If your lordship may kindly six. My lord, this is the landmark judgment, my lord, on the basis of which how 107 proceedings is to be initiated. Your lordship may kindly see first and foremost paragraph number 33, if I can place it, my lord. The section is aimed at persons who cause a reasonable apprehension of conduct likely to lead to a breach of peace or disturbance of the public tranquility. This is an instance of preventive justice which the courts intended to administer. The provision, like the preceding one, is in aid of orderly society and seeks to nip in the bud conduct subserve of the peace and public tranquility. For this purpose, the magistrates are invested with large judicial discretionary powers for the preservation of public peace and order. Therefore, the justification for such provisions is claimed by the state to be in function of the state, which embraces not only the punishment of the offenders, but as far as possible, the prevention of offences. Thereafter, that if your lordship may kindly takes up paragraph number 36. The procedure begins with.
Just a minute, let me see.
Yes, my lordship may kindly see. Judgment print out. My lord, can I please, my lord, paragraph 36?
Just a minute.
Yes, sir. Yes.
Yes, 36.
Yes, my lord. The procedure, how, my lord, 107 is initiated. The procedure begins with section 112. It requires the magistrate acting under section 107 shall make an order in writing setting forth the substance of the information received, the amount of the bond, the term for which it is required to be enforced, and the number and character and class of sureties, if any, required. Since the person to be proceeded against has to show cause, it is but natural that he must know the grounds for apprehending a breach of the peace and disturbance of the public tranquility at his hand. Although the section speaks of the substance of the information, it does not mean that the order should not be full. It may not repeat the information bodily, but it must give proper notice of what has moved the magistrate to take action. This order is the foundation of the jurisdiction, and the word substance means the essence of the most important parts of the information. Now, your lordship may kindly see paragraph number 33 and thereafter that paragraph number 36. And your lordship will kindly see, my lord, whether the learned magistrate has acted in terms of this judgment on. This is the landmark judgment, my lord, which guides the force of 107, how it is to be invoked. The second
Let us consider section 112.
Yes, my lord. Lordship,
so this was in relation to section 112.
It's section 100, no, my lord. 107 starting point is 112. Your lordship may kindly see section 100. Yes.
Section 112.
Am I at a CRPC? छोड़ो तुम अपने फोन में खोलो तुम लोग
Yes, what was the subject matter of this dispute on which the Honorable Apex Court has passed this
My
order?
lord, this was, my lord, subject matter, my lord, Madhu Limai, he was,
What was this dispute? Whether
my lord, similar, my lord, it was a,
let us see.
yes,
let us
lordship
see the
mechanics.
facts.
Yes, my lord, lordship mechanics. I have one copy, my lord,
Thank you. Madhu Limai.
ठीक है, thank you.
Yeah, look, the citation.
1971, yeah, 1971 Supreme Court. 71. Supreme Court 746.
746.
No, no, thank you.
सामने का टैब लेके कुछ लोग
My lord can have the hard copy, my lord. I've got the hard copy.
Let us see. Because let us see in what stage this order was.
Yes, my lord. This order, my lord, I'm telling you, I'm going to tap it.
Whether
Yes,
it was a final order or
No, no.
simply on the issuance of the notice.
No, my lord. Over here, my lord, what I respectfully, my lord, want to argue, my lord, in this is that this was, my lord, with regard to a challenge which was thrown, constitutional validity of sections such as 107 and 144, whether these sections were preventive detention measures, these preventive measures which were there in the CRPC, whether it was at all in consonance with Article 21 or not.
Yes.
Now, my lord, it is in this backdrop that the Honorable Apex Court, while issuing guidelines and issuing directions on how 144 is to be dealt with, has also issued directions as to how 107 has to be dealt with. If your lordship may kindly sees, my lord, the scope, which is why my lord had placed those paragraphs that it states as to how 107 is to be initiated also. इसका टैब में खुल जाना उसके बाद
Yes, record an order. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. This patient is directed to quash the proceedings being NCR number 218/2025 under section 107/116 within bracket 3/108 of the Criminal Code of Criminal Procedure 1973, arising out of MP case number 333 of 2025, now pending in the Court of Learned Special Executive Magistrate, Durgapur. Learned advocate for the petitioner submits that his client is implicated in the instant case for the purpose of harassment. Learned advocate draws attention to the order passed by this court in the writ jurisdiction, in the writ petition filed by the petitioner, as well as different orders passed by the administrative authorities taking possessions of different lands. Upon learned advocate also draws attention to the order of the Honorable Supreme Court in the case of Madhu Limai, Madhu Limaye versus Subdivisional Magistrate Mongher and others, reported in 1970 within bracket 3 SCC, page 746, and submits that in terms of the order passed by the Honorable Apex Court, the order passed by the learned magistrate cannot be sustained. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that as final order is not passed by the learned executive magistrate, but only a notice to show cause, at this stage, it may not be proper to stay further proceedings pending before the magistrate. Stop. Thus, the proceedings before the learned magistrate may continue. However, the petitioner will be permitted to represent himself by any learned advocate to bring relevant orders passed by this court and by the administrative authorities. Stop. In the event, however, no final order should be passed for a period of 8 weeks. For a period of 8 weeks after the Puja vacation. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let the matter appear 3 weeks after vacation. So the proceedings will continue.
Yes,
no further final order be passed.
Deeply grateful to your lordship. Much grateful. Much grateful.
Number 14.
Lordship, item number 14, Mr. Meet Guhora is appearing for the petitioner due to some difficulties, my lord. He is
Okay, not
unable-
today.
Not today, my lord. Great.
15. Please, my lord. My lord, an archetypal case of abuse. My lord, FIR was registered for allegedly non-payment of lease rental. My lord, the de facto complainant was the lessor. The accused company, my lord, the first petition was the lessee. My lord, kindly seize one page, my lord, before I take your lordship to the other document. If my lord's pleasure will be to come to the FIR. My lord, page 166. But it's annexure. It's P11, my lord, page 166. My lord has got 166. I'm sorry, my lord, my apologies.
Yes.
But sees, my lord, the sections is 318.4 and 316.2. That means, my lord, 420, 406, my lord, both cannot go together. Your lordship is aware of the position of law. My lord, kindly sees, my lord, occurrence of the offense. Since 2018 till now, that is on 5/2/2025. Because the lease agreement was initially in 2018. Till 2025, there was no dispute. Then, my lord, it was terminated by the lessor. And he issued a notice, rather she issued a notice asking for the rental, lease rental. But that was allegedly non-paid, for which FIR was registered. See the next page, the allegation in the FIR is one page FIR, my lord.
Okay.
But it's in vernacular, if I may place with your lordship's permission.
মহাশয়, আমি বিশ্বজিৎ মিত্র, পিতা সাচান সাচ, এই মর্মে আপনার নিকট জানাইতেছি যে আমার নিজস্ব সম্পত্তির উপর এয়ারসেল কোম্পানির একটি মোবাইল টাওয়ার আছে, যাহা মাসিক ভাড়া ও লিজ চুক্তিতে ব্যবহার করতে দিয়েছিলাম। উল্লেখ থাকে এয়ারসেল কোম্পানি 2017 সাল থেকে, মানে 6 from 2017 দেন, পুরোপুরি বন্ধ হয়ে যায়। দীর্ঘদিন যাবৎ টাওয়ারটি দেখভালের অভাবে টাওয়ারটি অত্যন্ত জীর্ণ ভগ্নপ্রায় অবস্থায় রয়েছে। মাঝে মধ্যে পরিচর্যা লোহার টুকরো খসে পড়ছে। কয়েকদিন আগে টাওয়ার থেকে একটি লোহার টুকরো খসে পড়ে, একজন আহত হয়। এই মর্মে একটি জিডি করি। আশেপাশের লোকেদের চাপে এবং পৌরসভার নির্দেশে আমি টাওয়ারটি খুলে ফেলতে বাধ্য হই। বারে বারে কোম্পানির সঙ্গে যোগাযোগ করা সত্ত্বেও কোনোরূপ উত্তর পাইনি। টাওয়ার শুরু করলেও কোম্পানির লোকজন আমার সাথে যোগাযোগ করেনি। আমি 2018 সাল এর থেকে এ যাবৎ বকেয়া মাসিক ভাড়া আনুমানিক 10 থেকে 11 লক্ষ টাকা এবং উক্ত টাকার ব্যাংকের সুদ সহ পরিশোধ করিতে বলিলে কোম্পানির প্রতিনিধিরা আমার কাছে 10 দিন সময় চায়। 10 দিনে উত্তীর্ণ হওয়ার পরেও যোগাযোগ না করিলে আমার মনে হচ্ছে কোম্পানি আমাকে প্রতারিত করেছে এবং অবিলম্বে জীর্ণ ভগ্নপ্রায় টাওয়ারটি খুলে না ফেলিলে পার্শ্ববর্তী যে কোনো মানুষের শারীরিকভাবে আহত এবং প্রাণহানিও হতে পারে। অতএব মহাশয়, আপনার নিকট প্রার্থনা এই যে কোম্পানিকে প্রতারণা ও মানুষের জীবন সংশয়ের হাত থেকে রক্ষা করার জন্য ব্যবস্থা নেওয়ার আবেদন করছি। No, my lord, how can this be a proceeding under, my lord, 420406? There should have been a civil suit which was not filed. And the agreement was prior to 2017. My lord, I was wrong in making a statement that from 2018. And I just show the lease agreement, my lord, the agreement, original agreement, my lord, your lordship will have, my lord, at page, my lord, 107. Sees the time, my lord, the date as such. My lord, sees the date, my lord, when it was originally executed. P4107.
Yes.
My lord, sees the date, my lord, the deed of lease is executed. Then, my lord, sees the date. 31st March 2006. My lord, from 2006 to 2018, admittedly no complaint, no grievance regarding non-payment. Now, from 2016 to 2025, there was a grievance. Since that, my lord, suit was time-barred, my lord, then FIR was filed and the case was registered. But it's absolutely a recovery proceeding, my lord, which was reprimanded by your lordships in the Honorable Supreme Court time and again. But I'm requesting for notice and stay.
Yes. Learned advocate for the petitioner is present. Her learned advocate for the petitioner. Peruse the materials on record. This application is made seeking quashing of here case number 522 of 2025 arising out of Baduria police station case number 65 of 2025 dated 5th February 2025 under section 318 within bracket 4 stroke 316 within bracket 2 of BNS 2023 presently pending before the court of learned ACGM Boshirhat. Top is submitted by the learned advocate that the allegations made against the petitioner by the de facto complainant are all civil in nature, and the de facto complainant, instead of invoking the civil jurisdiction, has filed this complaint to harass the petitioner. Learned advocate also submits that the allegations made do not constitute offense under section 318 within bracket 4 stroke 316 of within bracket 2 of BNS 2023. Upon perusing the petition and upon hearing the learned advocates and considering the materials on record, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings of GR case number 522 of 2025, now pending before learned ACGM, Additional Chief Judicial Magistrate Boshirhat, for a period of 4 weeks after vacation.
Most obliged.
So this is an application under section 429 of the BNSS. Lordship, I am praying for early disposal of the Expeditious. Lordship, case was registered in a year 2019. Ondal PS case number 223, 6/8 of 2019. Charge sheet was submitted on 2019 itself.
The case was instituted
in 2019, 6th of August 2019.
against this
Accused.
opposite party number 2.
Against the petitioner accused. Lordship. Petitioner is
The
the
petitioner accused.
Yes, Lordship.
Okay.
And charge sheet was submitted on that year, 30th of December 2019.
So petitioner is the sole accused.
No, Lordship, there are other accused. There are other accused, Lordship.
So how many witnesses are examined?
Lordship, in charge sheet there are 18 charge sheeted witnesses.
Okay. How many witnesses are examined till
No,
today?
Lordship, witness examination proceeding has not yet started, and Lordship, our last date was 30th of June, and my instruction is next date is on December 2025.
No, but so far your charge sheet shows that the year of WA is still pending.
Yes, against 3 accused persons.
So that is why the case is delayed.
That's if your Lordship just give a direction to proceed. As expeditious, Lordship, I have the copy of the type copy. The last
Right.
order,
The trial cannot be commenced as because this year of
three
WA.
accused absconding, Lordship, and accused filed absent petition is also there. And due to the one occasion, I must be candid. On one occasion, there is a resolution in the Durgapur Bar Association. That's why case was adjourned. That is on 9th of August 2024.
9th of August?
2024.
Okay. Now, when is the next date fixed?
Lordship, December 2025.
December?
This year, December, Lordship. Last date was 30th of June, and thereafter it was fixed on December. Lordship. I don't know the exact date.
Service upon this statement, then we may apprise your lordship about the position of the warrants.
Okay. Yes, learned advocate for the petitioner is present. Heard learned advocate for the petitioner. The petitioner in the instant case has prayed for expeditious disposal of here case number 1538 of 2019, presently pending before learned judicial magistrate, 3rd court, Durgapur.
So it is second court. Judicial magistrate, second court.
So
Durgapur.
your cost title says 3rd court. Okay, let me see your prayer. Pending before judicial magistrate. Yes, your prayer also says 3rd court.
No, see, it is second court. This is Sierra 3040.
No, this is
second court written in my.
But you see your petition.
But if Sierra 30 order dated 20th of January 2025. Really?
No, this is Sierra 3040.
3040.
Yes,
Ondal police station case number 223.
No, Ondal police station case number 285.
Okay. 285.
285.
Lordship, then I stand corrected. But yeah, clerk has mistaken, Lordship. Here in this case, there are 7 witnesses.
No.
7 cash-sheeted witnesses.
So far, this case is concerned. Year of WA is pending. 3040.
3040.
You see, Sierra 3040.
Yes.
That is year 1538 of 2019.
Yes, Lordship. 1538 of 2000. Yes.
Here also year of WA is pending.
Yes.
Okay. It appears from record that year of WA is also pending with regard to some of the accused persons, for which the trial could not be completed. In the facts and circumstances, the petitioner is directed to cause service of notice upon the learned public prosecutor within 1 week.
Here and now, I have the copy. Within prior to vacation, Lordship will dispose of.
Serve the public prosecutor
Within this week.
Yes, let this matter appear on 17/9/2025.
Lordship, similar order with respect to item 19. Here case number is different only.
Item number?
19.
19 also, let it appear on some other date. This is 18.
No, Lordship, this is 16.
16.
This is 16.
Okay, item number 19.
Yes, Lordship. Here only case number is.
Let it be called.
Lordship, I'm sorry.
17.
Item number 17, I'm praying for not today.
Not today.
18.
My lord, I am for the petition. My lord, this is an application for expeditious disposal of a suit registered in 2024. Till date, the hearing of interim maintenance is pending. The last date was on 5th of
This
June
is about expeditious disposal
of a match suit under section 120.
of the maintenance case.
Yes, my lord. My lord, last date was on 5th of June 2025 and the next date fixed is on 24th
Not
of
for
March.
the petitioner wife.
Yes, ma'am.
Have you received any interim maintenance?
No, my lord. It's pending.
Okay, 24, okay. Yes, record an order. Learned advocate for the petitioner is present. Her learned advocate for the petitioner. Learned advocate for the petitioner submits that the petitioner has filed a case under section 125 of the Code of Criminal Procedure, being M45/2024, now pending before the learned judicial magistrate at Bongaon, North 24 Parganas. Stop. It is further submitted that although the case is pending from 2024, but till today, the application for interim maintenance is not taken up for hearing. Stop. It appears that by order dated 5/6/2025, the learned magistrate has fixed 24/3/2026 for hearing of the interim maintenance. Stop. In the facts and circumstances, this court is of the view that no fruitful purpose will be served by directing service of notice upon the opposite parties. Stop. Thus, this application is disposed with a request upon learned judicial magistrate at Bongaon, North 24 Parganas, to dispose of the application for interim maintenance within a period of 2 months from the next date fixed.
Grateful.
Lordship, this is Ondal Police Station 223. Similar order may be passed in respect of. It is also pending before the judicial magistrate second court. Here there are 18 charge sheeted witnesses.
Okay. This is pending before learned second
Judicial
court.
magistrate second court.
Okay, this is also same
Yes.
state of affairs.
Yes, yes.
Yes, record an order.
2 cases lodged against the petitioner.
Learned advocate for the petitioner is present. Her learned advocate for the petitioner. This application is directed with a prayer for direction upon the learned judicial magistrate second court Durgapur to dispose of GR case number 1264 of 2019, of which the present petitioner is an accused. Stop. Learned advocate for the petitioner submits that although the case is pending for a long period, but there is no chance for expeditious disposal, as it appears that ER of WA of 4 of the accused persons are still pending. Thus, the petitioner is directed to cause service of copy upon the learned public prosecutor. Let this matter appear on 17/9/2025.
Yes.
Lordship, I am appearing for the petitioner. Lordship, this is an application under section 397 and 401 of CRPC, and my revisional application number 09 of 2023. This is since pending from 2023. I am for the revisionist in the revisional application. Lordship, last date was fixed on 4th September 2025.
This is which order? This is against
charge hearing. Which is still which is connecting in GR case number 575 of 2021.
17/1/2025. Okay, it was fixed for arguments.
Fixed for argument. Lordship, kindly see. De facto complainant, it's taking a lot of adjournment. Lordship, and my application was pending since 2023.
Your application is for?
I am against for the charge hearing, and the GR case is pending in ACGM Khatra, Bankura. More than 20 dates has hovered, Your Honor. Your Lordship, I beg to apologize. I'm praying for the expeditious disposal for my.
How long it is pending?
Lordship.
2023.
2023.
Yes, record an order. Learned advocate for the petitioner is present. Learned advocate for the petitioner. This application is directed with a prayer to direct the learned additional district and sessions judge Khatra Bakura to dispose of the criminal revision case number 9 of 2023 expeditiously. Stop. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that no fruitful purpose will be served by keeping this matter pending and by directing service of notice upon the opposite parties. Thus, this application is disposed with a request upon learned additional districts and sessions judge Khatra Bakura to dispose of criminal revision case number 9 of 2023. Yes, when is the next date fixed?
31st of October.
Within a period of 4 weeks from the next date fixed.
Lordship.
Oh. Initial.
Our expeditious trials, do we serve a copy of the application from the
Yes. No. That is dispensed with. Yes. When the matters are with regard to expeditious trial. No. In one or two cases it is being served. Otherwise, it is not being served. কালকে ঠিক আছে আর ইনিশিয়াল আছে